For orders, item numbers 1 and 2.
May it please Lordship. My Lord, I have filed an IA praying for, my Lord, this is IA number 89 of 24.
Complete this page 14. How can you complete it in this?
My Lord,
Human.
Lordship, the work is, it's, in fact, it's on the verge of completion. My lord.
How? See, page 14.
My lord, this is only earth cutting, this work. Work is earth cutting only. Not black topping, earth cutting.
Hmm?
Earth cutting only, earth cutting.
It's only outcutting.
Yes, my lord. Not-
Earth cutting is part of the work, Lord.
as far as the lordship permits
And-
me,
2 layers of WPM, retaining
No.
walls, culverts,
as far
site drainage.
as far as the PMGS work is concerned, that was different. But this one, the pending one is earth cutting. And now, as I have
What
said
does
in my,
outcutting have to do with the construction of the road? Means you are going to only cut the road, but the road you don't make.
my lord, the remaining is as I have said in my IA. I have annexed the progress report given by the competent authority executive engineer, in charge executive engineer. The only remaining portion is 4% and 5% in respect of two works, my lord. As I have prayed, make a submission on the last occasion, that as far as PMGS, that was completed pursuant to the court's order, my lord.
What does the government say? Ask the government to file an affidavit.
Yeah, they have filed.
This is by petitioner, huh?
Correspondent. 1 to 5.
Government's affidavit. What is the status of the work?
H2, where 3. Where 3, H2.
So Additional Advocate General, have you looked into the affidavit filed by the state?
Yesterday I,
You seen the pictures?
yes,
Does it show that it has been completed? Page 8. Does it show it is completed? More particularly the PMGSY work. You say that it has been completed on March 2024. Is it completed? Does it look like? See these pictures?
If Lordship permits me to say, Lordship, yesterday I met the executive engineer of the work in charge. According to him, the papers are processing the file. Otherwise, according to him, NQM, National Quality Monitors, they came on 22 May 2024 and found the job was found to be satisfactory as officially. Monitor came from central government. Then, according to the engineer, after every 3 weeks, they will keep coming for visit for 3 months. After every 3 months, they'll keep coming for inspection till 5 years. So therefore,
Understood. How, if that is so, how can you say that this is a work which has been done? We have seen a lot of PMGSY's work
yes,
in the Assam also. It stipulates the entire completion of the work. Does, at page 8, does it show that it is a completion of the work?
my lord, that was completed. The work as far as PMGs were concerned, as I have said, my lord,
No, forget about whatever the executive engineers are doing. This court has lost in absolute confidence upon these officials. Does it show from these pictures?
my
It is
lord,
done.
with due respect to the pictures, my learned friend, he has not stated whether this was after the judgment or before or any date was specified here. So that can be after, before 3 years, before 1 year. What does this picture shows? That's what
Kindly see page 17.
my lord, I have this with me.
Yes. The date is 4/6/2024. State of affairs, this is the road. I think a CBI inquiry would be fit. The call for a CBI inquiry on all the officials, including the joint secretary who has filed this stuff. The very serious aspect of the matter. You can't take this court for a ride.
I could agree about that. I could agree.
In
My
fact,
own-
in fact, let us see. Where is this petition? Is an I asked an order. Where is my order? This one.
It's 17. My lordship, I'm sorry, lordship, that the picture shows on page 17 is conjunct to arcane is only for art cutting, not black topping. My junior has just right to point it out. That's not black topping. That's not under PMGS, my lord.
Lordship, that is misleading, Lordship. I have annexed the working estimate. I have placed. Of course, it does not include black topping, but it includes 2 layers of WPM, Lordship.
Therefore,
And
lordship,
protection works, Lordship. I have placed it on record on 22nd of February 2021 by filing an affidavit, Lordship.
page 17 is of a different location, whereas my lord, what lordship is concerned is about PMGSY, my lord.
Now, are we to understand
Yes.
when there is a work order is for construction of road from Akin to Star Lake, construction of road from Lefroy to Mole, and construction of road from T1 to Konjang, we are to understand that it is only earth cutting. Show me the scope of the work wherein it is shown that it is only earth cutting. Show me that.
Lordship, I have it filed on 22nd of February 2021. At page 48, Lordship, the scope of the work.
22nd of February 2021.
Yes, my lord. The item of work along with the cost, it is clearly reflected. There is cross drainage, protection works, and road compositions include WBM grade 1 and WBM grade 2.
Yes, not black topping. Not black topping.
Excavation works. Now he is only mentioning earth cutting as excavation work. Page 48, Lordship.
Construction includes earthwork, ordinary surface drainage, cross drainage, boom pipe, culverts, so and so. So this construction from Aken to Star Lake, there is no black topping.
No black.
No black topping, Lordship. But these things have
Earthwork.
nothing have been done,
That
Lordship.
pertain to earthwork in excavation, earthwork in
Construction
ordinary,
from so and so, earthwork, foundation, plain
earthwork
cement,
in soil or ordinary soil,
machinery, black filling behind apartment, boom pipe, pipelines. So and so.
all the pictures my learner friend has enclosed is only to do with Aken to Star Lake and also Molhe to
Kindly come to page 49.
Lepore to Molhe.
Page 49 of the affidavit filed on 22nd of February 2021.
My lord, this is affidavit filed on 22/2/2021.
Kindly come to page 49.
Yes, my lord. Working estimate for work construction. Construction of work from Lepore to Molhe. Yes.
Now, what is there? Earthwork, excavation of soil. Then you kindly come to next page. Construction of earthen soldiers, B 3.18. Then you come back again to B 4.9.131, providing laying, spreading and compacting stone aggregates of specific size to WBM specification, including spreading in uniform thickness, hand packing, rolling with so and so, booming so and water area by manual means using so and so. Okay? Doesn't this WBM consist
That
of
is fine.
black topping? Then what is
Black,
this
not
black
black topping, not black topping. Only swelling, not black topping. Yes,
WBM.
it's not black topping.
Yes, spreading of boulders, Lordship, and small those stones, Lordship.
Filling up the pothole with stones,
So,
swelling.
yes.
These are-
On top of that, Lordship, black topping normally comes. Lordship.
Normally
No,
comes in a
no,
different thing. And we are not concerned.
Yes.
He has not come. in
Yes,
a
yes,
different
yes, yes. But that is not black topping, like he has said, black topping is not included in the work, Lordship.
So black topping, if it is not inclusive, better instead.
Yes.
Yes,
madam.
Lordship.
We are not concerned.
It's not
Yes,
included.
Lordship.
Yes.
Yes, but WBM has not been done, Lordship.
Huh?
This WBM has not been done.
Are you
Swelling.
saying that the PMGSY work also does not include black topping?
Black topping?
It
PMGSY
includes,
is blacktopping.
it includes blacktopping, Lordship.
Huh?
Here. PMGSY includes blacktopping.
Cannot be like that. Unheard of.
PMGSY includes blacktopping. The other roads, Lordship, from Blackbird to Mole, Aken to Star Lake, those two work orders issued, Lordship. They do not include blacktopping. Only WPM works. But this, Lordship, has also not been executed. This WPM has not been done.
In either of it.
No, no, no. It has not
They
been
have
done.
only done for excavation.
Yes,
Art
Lordship. Yes,
cutting
yes.
is going on.
Yes, Lordship.
My,
Yes.
my lord.
And in some portion of the road, Lordship, that is from Kanjang to Akin village, Lordship, they have done some WPM works, Lordship. But beyond Aken village, Aken is a large village, and then from Aken to Molepos, Molepos is the name of the pillar which borders Burma, Lordship, Myanmar. So from there to that area, Lordship, nothing has been done. And from Aken towards that Molepos, Lordship, and Star Lake, after about 1 kilometer, there is a camp, Lordship, for sheltering laborers, Lordship, who are engaged in the sawmill, Lordship, of the respondent number 7. So till that, Lordship, log trucks, 4x4 with special care vehicles can travel, and mountain bikes, Lordship. But beyond that, Lordship, no vehicle can travel. This is, Lordship, one of the most backward areas in Nagaland, Lordship. In fact, in the country, Lordship. Even if you, Lordship, if you go there to the Lordship, you will find people roaming around barefoot,
Is
Lordship.
the state happy with the work? Is the state happy with the work which has been done? Because the state says that they have done one work, they have completed in 100 March. But is the state happy with it?
You are telling for me from time to time.
File an affidavit by the Joint Secretary saying that he has duly completed the work in the month of March 2024. I'm asking, is the state happy with the work that has been done, taking into account the pictures which have been now placed by him? Is the state happy with it? Because you see, there is a aspect. We are concerned with the public interest. We are concerned with the money which have already been paid long time back on the basis that he has already completed the work. When he has not even started. This is the state of affairs.
The prayer of the petitioner is to have a good road. Let the timeline.
Earlier we have he's asked only till April. He asked only till April. We gave him till 35, 31.5. Then also therefore we directed the matter to be listed on 3rd. Nothing has been done. It is yet to be completed. And you say with those photographs of earth cutting done, which he himself admits in his IA, you say that 96% of the work has been done. Isn't it something of very serious aspect of the matter?
Because of could be due to climate factors.
No, we are not concerned with that. Whatever may be, that is another aspect of the matter. He may not be able to complete it. But how are you certifying it that 96% of the work has been done? When there is nothing, no WBM2. Understood, blacktopping is not there. But what is the WBM2 is not there. He's still going ahead with the art cutting. Kindly see his eye. See his photographs of the eye. Where is the WBM here? At page 14. That is his admitted stand. And you say that 96% of the work has been done.
My lord, as far as page 14 is concerned, this is Lepori to Molhe, and also first page, first part, then below Akin to Star Lake. So earth pitting and then culvert, Lordship will see they are continuing with the work, the earth cutting and culvert. The remaining portions.
Understood.
Yes, ma'am.
Where's the blacktop? Where's the WBM? No stones even.
But
Where's the stone?
that will follow, my lord. That will follow. After Arkin.
So the stone is only 4%. You certify, your executive engineer certifies it to be 96% have been done. How do you say it to be 96% of work being done? See, he's forget about what the petitioner has done. It is the self-admission on the part of the respondent. Does it show in any manner that this anything of the can it be said that 96% has been done? Where is one pebble out here?
My lord,
Not even a pebble. Forget about the WBM.
Lordship will see only we have shown the picture only where we are presently engaged. So therefore, only earth cutting. The remaining where we have done that can
Where
be shown.
is that photograph that we have done?
I have not annexed that.
Then-
That-
This is a
Correct.
good case to be.
The finished part I haven't.
Our
and
chief is coming next week. I think this is a fantastic case to be placed before him. That this is what the state of Nagaland means. If you get a better understanding on this aspect, how roads in Nagaland is made, I'm a bit shocked. How can there be a PMG, SY or anything, or even a construction of a road without blacktopping? Is never heard of. Because it is 100% that road tomorrow. You may have given specifically the work of excavation. It's another aspect. But no, your entire work order says construction of the road. Road, but there is no blacktopping. How do you construct a road? And taking into account the terrain out here in Nagaland and hilly area, that road tomorrow, after one rainy season will go, would have no existence. Isn't that properly made road from Dimapur to Nagaland, Kohima is losing existence, where there is blacktopping, even the protection being given, it is losing. Here you have given a contract only for the purpose of earth cutting and construct, but it is a construction of road. And you say 96%. We fix the matter next Thursday. Chief is sitting.
Lordship, if Lordship
And
can.
in the meantime, I give you the opportunity of bringing on record what are the photographs which are there to show that you have completed. I think this is a better option. Let him consider for granting you extension.
If Lordship
This is something which needs to be taken note. It's a glaring example of something illegalities of the. Yes. Just for the purpose to see a road, they are only for excavation. Nothing is there. How is it possible?
my lord,
I remember that means 1985, 90s, there used to be this type of contracts. But I completely forgot that Nagaland still follows this type of contracts. Construction of a road in a hilly area, no blacktopping, just excavation. And certification being given, 96% have been done. 1 to 100%. And there's no black.
And that also for an unbelievably high amount, 30 crores, Lordship. There are also documents I have.
Apart from that, there is the overlap. Overlap.
Yes, my lord, my lord.
That
With
has been,
overlaps with-
no overlapping. That government has filed with no overlapping.
Government says it's a different thing. Government says many things. There's no.
My lord,
We have perused the
I have
SIA. We have heard Mr. A. Joe, the learned counsel, appearing on behalf of the commissioner, as well as appearing on behalf of the applicant, and Mr. So-and-so, the learned additional advocate general, appearing on behalf of the state of Nagaland, and Mr. So-and-so, appearing on behalf of the petitioner in the public interest litigation. This is an application filed seeking extension of 15 days to complete the pending works between Lefroy to Mole and Akin to Scarlet under the Peak District. On an earlier occasion, when the matter was taken, a detailed order was passed, wherein the various illegalities which have taken place in respect to the construction of these three roads have been gone into detail, for which this court, we don't intend to again repeat the same. Be that as it may, by the said order dated 22/9,
yes, ma'am.
22/9, 29 to 2024.
Yes.
On the submission made by the learned counsel appearing on behalf of the respondent number, the applicant hearing with the respondent number 3 to the public interest litigation.
Respondent number 7.
7, ma'am.
7, Lordship.
We said 7.
Yes, yes.
7. There's respondent number 7 to 7. This court had granted time to complete all the three road works by 31/5/2024. In spite of the fact that the council appearing on behalf of the respondent number 7 on instructions have stated that they would be able to complete the work by April 2024. Be that as it may, admittedly, all the three road works are not completed, and it is under such circumstances the instant application has been filed for extension. It is, however, very relevant to take note of that the state respondents have stated by way of an affidavit that 100% of the work have been completed in respect to one
PMGSY.
road, that is the PMGSY road from T01 to
Panjang, Lordship.
so and so. However, in respect to the other two roads, 96% of the work has been completed. We have strong reservations against the stand taken by the state respondents, taking into account that from the photographs which are placed before the court, even by the respondent number 5 in the application, do not show that 96% of the work seems to have been completed. Be that as it may, Mr. A. Joe, learned counsel submits that the photographs which have been enclosed are only those photographs wherein the present work is being carried out. However, the photographs as regards the earlier works, the works which have been duly completed have not been placed. He therefore submits that some time may be granted to place on record those photographs. This court we have also perused the affidavit which have been filed, additional affidavit which have been filed by the state by the petitioner, wherein the certain photographs have been enclosed. A perusal of those photographs, however, do not inspire the confidence of this court that confidence of our confidence as regards the completion of the work or near completion of the works in respect to the three roads. Be that as it may, this court, taking into account the submission made by Mr. Ejo, grants liberty to place on record those photographs. To list the matter again on 13/6/2006.
My lord, I have spoken. On 13 till 16, I have one POXO matter in Pinsang.
When the Chief Justice is here, you can't say all
So
those things.
therefore,
Other
my lord,
matters,
if
things are
lordship
better.
can kindly grant me 15 days.
No, no,
And-
no. You are asking 15 days to complete the work.
My lord, because in the interest of public, they want raw.
You see, the Chief Justice is coming, new Chief Justice coming to the High bench for the first time. Let him also know what is the state of affairs.
My lord, lordship he'll be coming. He'll keep coming and we'll be receiving
For
him,
me,
welcoming
it's
him.
different. I'm here. But
Whoever
let him
comes,
first-
we are welcoming everyone, Lord, my lord.
Whenever he first picks up the matter, let him know what is actually happening.
My lord, in fact, on the first day, we should receive him with good note. My lord, therefore, if lordship can permit me at least my prayer, grant my prayer. Because on the first day, we receive him with the sad note, that may not be very,
Okay, let it not be on the first day. Let it be on the second day.
my lord.
14/6. 14/6.
My,
Obliged, my lord.
May I please, Lordship?
Yes.
My Lord, hearing item number 9. My Lord, government has filed affidavit in opposition. I may be allowed at least 2 weeks' time to file reply, my Lord. Admission 9. State has filed affidavit in opposition, so I'm yet to file reply.
Item number 9.
9, my Lord.
What is the matter about?
Here, the petitioner, they are challenging the order which was passed after the retirement. So they do not have the locus to challenge the action of the government, Lordship.
We'll pick up the
Yes.
matter, we'll see when.
For motion, item
Wait, please,
number
Your Lordship.
1.
My lord, I beg your apologies, my lord. My lord, may kindly allow me to withdraw item number 21.
Why? They have filed the affidavit.
No, your lordship.
They were supposed to file the affidavit.
My lord, may kindly allow me to withdraw with liberty to file afresh because I may need to take a different approach, my lord. Because the same approach, the similar case has already been dismissed. So my lord, may kindly give me the liberty to withdraw
But
and
this is
file afresh, my
Dimapur.
lord.
This is Dimapur.
Yes, your lordship. But my lord, may kindly allow me to withdraw.
So another very interesting thing, that day I was just going through it when you say that. The notification which was given on 4/3/2024
My lord.
has been widely circulated, news out there in all newspapers also.
My lord.
And you didn't know.
That I was not aware, my lord. I beg your lordship's apology. Even otherwise, my lord, I may need to take a different approach. So my lord, may kindly allow me to withdraw.
Anyways, let me have a look at what they say in their. We'll take it up. I'll allow you to withdraw, don't worry, but have a look at what they say on it. Because earlier, they only placed the matter before the court without any affidavit. Let's see their affidavit first. I will allow you to withdraw.
I was not served a copy, so I wasn't aware, Your Lordship.
We'll see when it is.
Item number 1.
Yes.
My lords.
Report.
Well, it's in this case, the state has now filed counter reply. So, my lord, I leave it to my lords. Either my lords can consider this application or my lords can hear the matter finally. We will file a rejoinder within a short time. So, just after my lords, sometimes in July, subject to my lords' convenience, matter can be taken up for final.
Mr. Counsel, the state have already filed their affidavit in opposition in the.
Yes, my lords.
So.
I want to file a rejoinder, my lords, because there are legal issues which I want to raise for my lords' consideration.
But what you are asking in this IA.
Yes, my lords.
Granting you a provisional pension at this stage.
My lords.
Then whether your entitlement to pension at all is to be taken into consideration.
Yes, my lords.
Once you are entitled, then everything else will follow.
My lords.
To be granted any provisional pension if your entitlement of pension at all is at stake.
My lords, since the state was not filing reply for last 9 months, that's why we moved this application. But since now, my lords, the state has filed reply, so we will file rejoinder and my lords can decide the matter. Whatever, whether I'm entitled or not, my lords will decide.
So you won't press this IA now?
I'm not pressing, my lord, but with liberty to raise it again if necessary. So I'm just, or I will keep it pending, my lords. I will argue the matter finally after filing my rejoinder.
They have already
The
filed
allegation
their
is also-
affidavit. You want?
Yes, my lord. They have filed their counter reply. So my lords kindly permit me to file a small rejoinder and then my lords can hear it finally.
Chalo.
My lords, sometimes in July, my lords, subject to my lord's convenience.
IA, we do one thing, we close the IA now.
Yes, sir.
With liberty, my lords. I'm withdrawing with liberty to agitate the issue if required. Otherwise, my lords can, I leave it to my lords. My lords can permit me with liberty because they may again matter linger on. So,
The allegation is also misleading, Your Lordship. The allegation made in the IA is also misleading, so this may be.
Anyway,
dismissed, Your Lordship.
we allow him to withdraw.
yes, my lords. I'm withdrawing with liberty, my lords, so that the judicata does not come in my way.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so appearing on behalf of the government of Nagaland, state of Nagaland. This is an application seeking in the interim a direction upon the state respondent number 4, to pay to the petitioner her provisional pension till such time the matter is finally adjudicated by this court. The counsel appearing on behalf of the petitioner submits that taking into account that the affidavit in opposition has already been filed by the respondent state, he is not pressing the instant application. He, however, submits that in the circumstance that there is a further delay in disposal of the petition, he may be permitted to again file. So taking into account the above, the score closes the instant application as withdrawn. However, liberty is given to the petitioner. In the circumstance, the matter cannot be disposed of on an expeditious date.
My lords may permit me to file rejoinder also, my lords.
In the main petition, he said, it is seen that an affidavit in the counsel appearing on behalf of the petitioner submits that an affidavit in opposition has been filed on 22nd of March 2024. He submits that he would like to file he submits that the petitioner would like to file a short reply to the same. Accordingly, list the matter again on 4th of July 2024.
My lords, 4th will be difficult for me. It requires physical appearance because constitutional law issues are there. So sometimes, my lords, after vacation.
Mr. Counsel,
Lordship.
first of all, the vacation is not here.
No, my lord, July vacation, my lords. I'm told my colleague, Mr. Lotha, says
Kohima, we have only a longer winter vacation
oh, my lords.
because the weather is very nice.
So, my lord, will it be possible for 24th or 25th of July? If my lords can accommodate.
On one hand, you are delaying the matter.
My lords, I will have to come from Delhi. My lords.
On the 7th, you are asking on a date on 27th.
July, my lords, after vacation, the courts are opening on 21st. I'm told that is what Mr. Lotha has told me. So after 21st, my lords, any day subject to my lord's convenience. 24th, 25th, 26th, any day, my lords.
The matter again on 25th of July 2024.
My lords.
In the meantime, the affidavit we filed by 22nd of July by serving a
My lords.
hard copy to the respondents.
Obliged, my lords. Much obliged.
For admission, item number 2.
Yes. What is this matter?
Your Lordship, the petitioners are the Dobashis who are receiving 1993 ROP. So we're asking for the latest ROP, Your Lordship. Like the other regular Dobashis, we are performing the same duties
You are
at the
working
same
as
establishment, Dobashis. Dobashi.
you are working as Dobashi.
Yes, Your Lordship.
You are asking for equal pay for equal work.
Yes, Your Lordship.
Against vis-a-vis which post?
No, Your Lordship, for the post that we are serving, we are paid 1993 ROP. And we are asking for the latest ROP, Your Lordship.
That is another aspect of it.
My lord.
You are on one hand also asking for equal pay for equal work. Isn't it? Your first prayer.
Yes, Your
Direct
Lordship.
the state respondents to pay the petitioner the equal pay for equal work as per the latest ROP. But your case is that you are entitled as per the latest ROP.
Yes, Your Lordship.
What does the state say?
The finance department has also been made a party, Your Lordship. Not because they have any other points to contribute, but because of the financial implication, Your Lordship. So as far as the law point is concerned, their impletement is only to bring the,
Have you made the finance commission a party?
yes, Your Lordship.
Then why do they object to file an affidavit? You made some correction in you. No, finance commission is not a party.
He's made a party, Your Lordship.
When?
Completed.
It's there.
Yes, Your Lordship.
Finance commissioner is now a party. Now, finance commissioner has not filed the affidavit. Who is appearing for the finance commissioner?
My colleague is engaged in
Hmm?
another court, Your Lordship. It may be kindly be taken up after some time, Your Lordship. Vijimo is engaged in the court too, Your Lordship.
Where is he?
Can it be taken up after some time, Your Lordship?
The instant petition has been filed by the petitioners, claiming that the petitioners are entitled to their salary, no?
Yes, my lord.
In terms with the prevalent ROP rules
2017,
2017,
my lord.
as well as other consequential benefits. It is seen that the respondent numbers 1 to 4 had filed an affidavit in opposition stating inter alia that the instant petition is not maintainable in as much as the finance commissioner to the government of Nagaland, finance department was not made a party. Be that as it may, that the finance commissioner, government of Nagaland, have been duly made a party in the instant proceedings and have been arrayed as the respondent number 5. It is also taken note of that on various earlier occasions, the respondents have taken time for filing the affidavit in opposition on behalf of the respondent number 5. The dates are on 6/11/2023, 8/2/2024, 4/3/2024, 9/4/2024, and 9/5/2024. However, till date, no affidavit in opposition has been filed by the respondent number 5. Under such circumstances, at the request of the so-and-so, the learned counsel appearing on behalf of the state respondents, This court, for the ends of justice, grants a final opportunity to the respondent number 5 to file the affidavit in opposition, which the said affidavit in opposition has to be filed by the respondent number 5 on or before 2nd of July 2024. It is made clear, if the respondent number 5 fails to do so, the instant writ petition shall be taken up for disposal on the basis of the materials which is already available on court.
My lord.
List the matter on 5th of July 2000.
Lord, your lord.
For admission, item number 3.
Your Lordship, I'm mentioning on behalf of Livika, she's in dispose, Your Lordship, and she's supposed to file her additional affidavit, Your Lordship. 2 weeks time may be granted, Your Lordship, in this matter. Your Lordship. The affidavit is under preparation, Your Lordship.
What is the matter about? You see, additional affidavit to be filed by the government is going on for a long time.
Your Lordship, I've been informed, but that since there are 52 petitioners and the state is annexing the appointment orders, PGT decrees, and regularization order of all the petitioners, so it's taking time to collect the annexures, Your Lordship. So within 2 weeks, it will be filed, Your Lordship. So kindly grant 2 weeks, Your Lordship.
Where is the
And
petition?
since she's in dispose, Your Lordship,
Lordship, there is an order on 16/2/2024.
There's no repetition here. Oh. Yes, Mr. Jamil, what are you asking for?
We are asking for a great pay of rupees 4,600. In 2014, the cabinet has taken a decision to upgrade the few posts, numbering about 262 posts have been upgraded in 2014. And it was decided to grant a grade pay of 4,600. One batch in 2014, they were appointed and granted that scale basing on the cabinet decision, 4,600. We were upgraded in 2020 only, but
And what is the grade pay you are getting now?
4,400. And the contention of the government is that in 2017, the service role has been enforced. And in terms of the service rule, we are coming under the grade pay level of 11, that is 4,400. But our upgradation is based in the same cabinet decision, which was taken in 2014. And the persons who were appointed in 2014, they are enjoying that scale, that is rupees 4,600 scale. Whereas on the basis of the same cabinet decision, we were also upgraded, and the upgradation order is very clear that it is basing on the cabinet decision of 2014, but we were given only 4,400 pay scale. So there is disparity among the similarly situated persons, Lordship. Upgradation order is at page 30. And consequential order was issued on the same date, that is 5th March 2020. And the order says that the service rendered in the past shall be counted for all other service benefits except seniority. Therefore, except seniority, all past services will be given. That is inclusive of the pay, which is
The
a very
stand taken by the government in
Lordship.
the affidavit
Yes.
is on the basis of the Nagaland School Education Service rules.
Yes.
2006. You were
Yes.
appointed in terms with that rules?
No,
You are earlier.
we were already appointed prior to that. We have completed more than 20 years, many of us.
Hmm.
And before
So you are your PGT junior grade 3.
They have met in that manner.
Hmm?
Yes,
And as such, you are given the grade pay of 4,400.
yes, Lordship.
You claim that your grade pay should be 4,600, which is equivalent to senior PGT.
Yes. Because those persons who were appointed in 2014 is basing on the same cabinet decision where the decision was taken to upgrade 262 posts. But the only difference is they were prior in time and we were in 2020 only. By that time, the service role has given the force. But after coming into the service role, we were upgraded. But in the upgradation order, it is clearly mentioned by the government that all service benefits shall be granted except seniority. We are not claiming seniority, so there is no issue on that. But pay was not given. So it is contrary to the government own order, Lordship. Page 38 is very clear, annexure H.
38.
Yes. In paragraph 2, it is clearly mentioned that the
Of your
service
writ petition of this order.
writ petition, Lordship.
On
Page
sequence upon
38.
the upgradation of 59 posts of graduate teacher and primary teacher.
And in paragraph 4, they have referred to cabinet decision that is also 2014, that is prior to the service role came into force. So 2014 batch,
Why was the additional affidavit required from the government?
pardon, Lordship,
Why was the additional affidavit required from the government? Because there are various
On-
orders passed.
yes, on 6/2/2024, the matter was heard to a great extent. And then this honorable court wanted to know when we have acquired the P8 degree,
What degree?
P8 degree, Bachelor of Education.
Oh, B.Ed.
Yes,
Bachelor of
because
Education.
in school education department, there are 3 categories of teachers: primary teachers, graduate teachers, and then the postgraduate teachers. The petitioners are postgraduate teachers. And normally in the school education department, incentives are given to those teachers who acquire additional degree in the course of during the service career. So as an incentive, we were also allowed to go for further study. And then some of us joined as a primary teachers, some of us joined as graduate teachers. But then in the meantime, we have acquired MA, post-graduation degree, as well as the PE degree. So the government has taken a policy decision in 2014 and decided to upgrade 262 posts to the postgraduate post, Lordship. And that is because of the fact that the higher secondary schools were open in the state and so many schools were open. So there were shortage of teachers in the higher secondary schools. Therefore, government has decided to upgrade those teachers to that of postgraduate teachers. And then we were included in that, Lordship.
Now, what is your grade pay?
4,400 only. Their pay.
4,400 grade pay was earlier to 2017.
Yes.
Now only it is revised in 2017.
Yes.
So what is your grade pay now? Still the 4,000.
4,400.
Because in Sam, I find that after the coming into account of this is the 6th pay commission, the grade pay have also increased.
Yes.
Here, what is it?
Yes.
Will obviously increase.
Increase.
Huh.
That is as per the all, because prior to 2017 rules, Lordship, there was no great distinction between the postgraduate senior and postgraduate junior. There were no distinction prior to 2017 rules.
No, do we require the affidavit now? additional affidavit.
I don't think that will be necessary.
Let it be listed next week, so that
Huh?
it appear in this case.
Next week?
Yes, Your Lordship.
Why?
Because she's indisposed, Your Lordship. I'm not handling this matter. She's undergoing treatment, Your Lordship, even as we speak. Your
Who?
Lordship.
Miss Devika?
Devika, Your Lordship. Yes.
Oh, it has been submitted by Ms. So-and-so, the learned counsel appearing on behalf of the state of Nagaland. That Ms. Devika, he has been assigned to represent the state in the instant matter. She is undergoing some medical urgent treatment. Under such circumstances, the matter stands adjourned to be listed again on 20/26/2024. That are there properly read.
My learned friend has submitted that, let it be placed next week.
Understood.
Let it be
but,
next week.
Let us give her, she has to face Mr. C.P. Jameen. So, let's give it on 26. In the meantime, the respondent state shall file the additional affidavit. to make clear that if the additional affidavit is not filed by 18th of June 2024, the instant writ petition shall be taken up for disposal on the basis of the available materials.
Much obliged.
For admission, item numbers 4 to 6.
Matter is also handled by Devika, Your Lordship. Here the pleadings are complete. So this may be listed after.
Let
After
them
we-
file the affidavit in line.
May I please, Your Lordship? Lordship, I may be allowed to withdraw this writ petitions, Lordship, with the liberty to file a fresh, Lordship.
You want to file affidavit in reply?
No, Lordship, I want to withdraw. Like, in fact, we were supposed to, but Lordship, while this matter was pending,
You
Lordship,
want to withdraw all this writ petition?
Lordship, yes.
In absence of Ms. Devika?
Lordship, I have informed her, Lordship.
Okay. The council appearing on behalf, all the three.
Lordship,
Beleg ke liye badi. Matters are similar.
yes, Lordship.
Why do you want to withdraw?
Lordship, while this matter was pending, there was similar case that has been disposed of by the division bench that stating that the contingency appointment does not fall under the work charge, Lordship. So we want to file on the different line, Lordship.
You're referring to the state of Nagaland was the LMA?
Lordship, it's passed by the division bench and it's yet to be challenged, Lordship. Since 2022, it's passed on 2020. However, it's not been challenged till date, Lordship. There are 2 or 3 writ appeals, Lordship.
The council appearing on behalf of the petitioner submits that the petitioner have instructed that the petitioner does not want to further proceed with the instant writ petition. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Ms. So-and-so appearing on behalf of the respondent, so-and-so appearing on behalf of the state, submits that she has no objection to the date. Accordingly, the instant writ petition stands closed on withdrawal. So,
Lordship, I may be given a liberty to file a fresh, Lordship.
for what?
Lordship, in
This
difference.
is not done. You can't ask for liberty like this. Why?
Lordship,
You have to give me a good reason for that.
yes, I
Liberty,
have-
This court doesn't give like this. Give
But-
me a good reason. You have asked for regularization have been completed 30 years as on 2017. You filed the writ petition in 2022.
Lordship.
We are in 2024. You have already retired long time back under such circumstances.
Lordship, they retired on 2022, Lordship.
Then
2 of
why do
them,
you want
one
the
is yet to
liberty?
retire. Lordship, they were pursuing since then, Lordship. However, they were pursuing for regularization, Lordship, since then. However, their papers were not considered. So after retirement, they also approached the state respondents, however, they appear in the consent. So we filed after that only, Lordship. Since before the retirement, they have been processing the regularization, Lordship. However, while this matter was pending, there was a similar matter. So we had to withdraw to file on the
No,
different.
madam, you have to be very clear. You want to withdraw, withdraw.
Lordship.
No liberty interest. Liberty, liberty does not come. Liberty would not come because you have asked for regularization. Because it's not a small thing.
Lordship.
You have sought for regularization on the basis of the 30/11/2015, 3/11 or something. You have sought for regularization on the basis of that. Yes, Mr.
No, my lord, will kindly appreciate this. Whether it is ad hoc or temporary or contingency, your lordship, all are temporary in nature, my lord. So we have to challenge the notification. So until and unless the
What
liberty is
notification
granted
you
to
want
us,
to
up to the state's notification, my lord, which we were of the impression that it is covering your case.
No, what do you want to challenge? You want to challenge?
The 2015 notification, my lord.
Huh?
Because contingency, the word contingency is not included, but they are all temporary in nature. They performed a similar duty, similar responsibility, same post, my lord. But just because the word contingency was not included, contingency has
In
been
that-
sidelined, my
In
lord.
that office memorandum of.
Yes, your
30.
lordship. That on the basis of that only, contingency has been left out. So, your lordship, that needs to be challenged so that contingency who are also in the same nature, performing the same duty in the same post, my lord. How can contingency be sidelined when ad hoc and temporary are already covered, my lord? So we need to challenge this notification. Hence, my lord may kindly grant us the liberty so that the petitioners are not.
So your case is that the office memorandum of 17th March 2015 only talks about work charge and casual employee.
Yes, your lordship.
It does not take into consideration the contingency.
Yes, my lord.
But the petitioner hearing it are contingency workers.
Yes, your lord.
And as
Your
such,
lordship.
without the challenge to the office memorandum dated 17/3/2015, you cannot get your right of regularization.
My lord.
That's
Hence the liberty may kindly be granted to us, my lord.
Tell me that it should have been, but not on the basis of otherwise. Okay, now,
My lord.
the petitioners in the 3 writ petitions admittedly have been appointed on contingency basis. The petitioners have also rendered more than 30 years of service. And were granted the scale of pay.
Lordship.
However, on account of the judicial interpretation given that the office memorandum dated 17/3/2015 would not include contingency workers, the learned counsel appearing on behalf of the petitioner submits that the writ petition in the manner in which it had been filed would not entail or would not, in the manner in which it had been filed, would not succeed. Since a challenge being made to the office memorandum dated 17/3/2015. The learned counsel, Ms. So-and-so, submits that she may be permitted to withdraw the instant writ petition and liberty may be granted to refile by challenging the office memorandum dated 17/3/2015. This court, upon hearing the learned counsels appearing on behalf of the respondent, the petitioner as well as the respondent, is of the opinion that the petitioner should be granted the permission to withdraw the instant writ petition and liberty also should be granted Inasmuch as without the challenge to the office memorandum dated 17/3/2015, the petitioner would not be able to get the relief as sought for. Accordingly, the instant writ petition stands closed on withdrawal. However, granted the liberty as stated above.
Lordship, Lordship.
For admission, item number
All three,
7.
huh? Bilik.
Lordship, just a short matter, nothing to argue about. This is a case of
Short matter, but
assistant,
the petition seems to be voluminous.
assistant professors
Huh?
who were appointed without advertisement and without qualification.
The counter has not been filed by him.
May I please, your Lordship? Lordship, if I may be, I've been authorized by respondent number 4 to 8, 10 to 13, 15 to 21, 23 to 34, Lordship. Well, however, I have not filed my Bakalat Vatsalya.
Lordship,
Lordship, so in the
this case
meantime,
pertains to
maybe I'm not-
2022. They are just using delaying tactics. They have, some of them have entered their appearance before, but till now, none has even filed their affidavit or their wakalat nama.
I may just be allowed 1 week to file my counter for respondent number 9.
9.
Yes.
And you,
Lordship, I may be granted 2 weeks' time, Lordship.
you are appearing for whom?
Respondent number 4 to 8, 10 to 13, 15 to 21, 23 to 34.
Who is appearing for? So everybody's service is complete?
Lordship.
All respondents are represented?
Lordship.
Matter pertains to which year?
2022.
22. Okay.
Notice was issued in
So,
2022.
has the state filed the affidavit? When are you filing it? When? The instant writ petition is filed challenging the appointments made to the private respondents on the ground that the said appointments are in violation to the violation to what?
Lordship, they were appointed without advertisement as well as they don't have the qualification. They have no
Have been
qualification.
challenged. The appointment by way of the instant writ petition has been filed by the petitioners, challenging the appointments of the private respondents on the ground that the said appointments made to the private respondent by the state authorities was without issuance of any advertisement, as well as the private respondents does not have the due qualification to be appointed to those posts. First, it is seen that the respondents have, all the respondents are duly, have already put on their appearance and the service is complete. However, none of the respondents, including the state respondents, have filed their affidavits in the matter. Accordingly, this court, for the interest of justice, grants time till 3rd of July 2024 to file the affidavits by the state respondents as well as by the private respondents. Full stop. The matter be fixed again on 11th of July 2024. In the meantime, the petitioners, if so advised, would be at liberty to file such reply against the affidavit to be filed.
Obliged,
Much
Lordship.
obliged. For admission, item number 8.
May it please, your Lordship. Your Lordship, the petitioner's village is inhabited by 2 tribes. In the same village, the Simi tribe and the Sangtam tribe, your Lordship. Earlier, the post of GB, the Gaunbura, was held by one Ihoto Mungzar. And when he was the GB of the Simi tribe, he was Ihoto Yepto. But he decided that he would become Ihoto Mongzar, that is the other tribe, your Lordship. So my lord, once he relinquished the post of GB, the present petitioner, your lordship, being a descendant of Yepthomi clan, Yemshe Yepthomi clan, your lordship, he was recommended by the village as well as by the joint DB's council, your lordship. Now, after the whole decision has been taken that the present petitioner should be appointed as the Gaunbura of the village
Who appoints the Gaubura?
by the office of the commissioner in Nagaland, your lordship.
They appoint.
Yes, your lordship. So now, your lordship, what has happened now is the state respondents are keeping the file pending because the other tribe is objecting. As far as the Simi tribe is concerned, my lord, the Gaunburaship is hereditary in nature, your lordship. So somebody has written apparently a representation against my client, my lord, from the other tribe. On that basis, the appointment has been pending. So I beg your lordship to kindly issue a direction to appoint my client within a specified time.
How is the Gaubura appointed?
Your Lordship, page number 42, Your Lordship.
Huh?
Page number 42
Page,
of the
Writ
petition,
petition.
Your Lordship.
writ
Yes, Your
petition.
Lordship.
Which page you are saying?
My lord, the type copy is at page number 43.
43.
No, Your Lordship. I'm referring to Annexure 8, Your Lordship,
Form for settlement.
of the writ
Oh.
petition, Your Lordship.
No, no, what
Election.
is the rules for appointment of Gaubura?
Your Lordship, basically the client, they propose their name and the government appoint whoever the client proposed.
Because you say in your affidavit
Yes, Your Lordship. So,
that there was some firing incident on 27th.
yes, Your Lordship.
And because of that, the Sumi faction have withdrawn their
No,
signature.
the
No,
Sangtam.
the Sangtam faction.
No, here it says, can you see?
Which page, my lord?
In her affidavit, that from these letters, it is reported that the Santam GB, due to difference with Sumi GBs with regard to here, decided to withdraw their signature from endorsing the petitioner as a GB. Therefore, the forwarding letter endorsing the petitioner as GB has to be withheld till the matter is amicably settled between the two parties. Now, that is the reason why you have not appointed,
Yes, Your Lordship.
unless there is an amicable settlement.
Yes, Your Lordship.
So therefore, therefore, as this court is not aware of the system by which it is to be appointed, kindly point out what is the manner in which a Gaubura is appointed.
Your
What are the
lordship,
rules or how it happens? Is it on the basis of some customary law or is it on the basis of something? How do I know?
it's customary in nature, your
Your
lordship.
specific stand is there is some issue between the two factions out there for which somebody has withdrawn their signature and as such, we cannot do it unless they settle it. That's your case.
Yes, Your Lordship. And basically, Your Lordship, for appointment of the recommendation was made by both the Sangtam GB and the Simi GBs. And the Sangtam GBs withdraw. So there has to be a consensus, Your Lordship, and if I may turn to,
Now that I understand.
yes, Your Lordship.
You see, initially there was some recommendation, some letters were given by
Yes,
both the GBs,
Yes,
by the
both
GBs
the-
of Santam and so and so.
Yes, Your Lordship.
For the petitioner, but however, Santam has withdrawn and as such, you want that unless the
parties.
dispute is not solved there, but can you keep the post of Gambura just vacant? Like this? The only thing is some recourse has to be taken if you are the appointing authority. How it is to
But
be
if
settled?
there's a dispute between two parties, then. the
My
government
lordship,
is also
my
in a
lord may
fixed-
kindly appreciate this. I wish my learned friend would also assist this honorable court in all fairness to the extent that these are two tribes. So though they are living in the same village, your lordship, they are
But
two
you have
tribes.
to show me
Yes, your lordship.
why the commissioner has to appoint one and what is the procedure to be followed.
As far as the procedures are concerned, your lordship, that there are no rules as such. Because
Then
this
how
is
do you
purely
have-
on the basis of the
Recommendation.
customary law and the recommendation. As far as the Simi tribe is concerned, Your Lordship,
But don't you have a village council out there?
the village council is there, so the
Why
village
don't you go
council
to
has
the village
recommended.
council?
This issue has gone beyond the DB's, joint DB's code also, Your Lordship, comprising of the sanctums and the Simis, joint DB's code. And the joint DB's decision has not been challenged. So when that is also a judicial authority, judicial decision in itself, customary judicial institution, Your Lordship, when that decision has not been challenged, and just somebody writes a letter saying that we withdraw our recommendation, when there is already a judicial decision which holds the field, on the basis of that, how can the appointment of the GB be stalled till date, Your Lordship? That is the issue. And the other issue, as I have already pointed out before, Your Lordship, is as far as the Simi tribe is concerned, just like the Konyaks, it is hereditary. Kingship is hereditary, Your Lordship. So sanctums, they are not hereditary. Simis
So
were hereditary.
something by which you can be appointed. See, this court, you are asking this court to exercise a writ. The writ has to be issued if they have a duty to do so, which they are failing to do. Kindly show that there is a duty which they have, and how they are to exercise the duty. Show me that. If this, on the basis thereof, it appears that yes, the respondents are failing to do so, then this court will definitely pass an order.
Your Lordship, may I take Your Lordship to Annexure 2? This is the decision of the Joint DB's court. My Lord, the translated copy starts from page 26. May I read, my Lord?
You have a better copy? Type.
Yes, Your Lordship.
Page 29.
Yes, my Lord. Yes, my Lord. Page 29. May I read, my Lord?
Yes.
This is the English translated version. Government of Nagaland Office of the Sechung and Arnato DB's Joint Court Camp, Yanzitong Village Council Hall, dated 36/2015. Dated 26/7 May 2015. Dated 29/30 June 2015. They had several sittings, my Lord. Appeal Kheuto GB Yem Sheklan, Yanzitong Village. Respondent Z Ihoto Head GB, Yanzitong Village. Settlement order between Yem Sheklan and Yetuli clan. Sri Kheuto, the present petitioner, Your Lordship. GB Yanzitong Village and Sri Kohvi Head GB, Khatoi Village had appealed on 24/11/2014 before ITC Agnato against Z Ihoto Head GB for his publication on 23/1/2014 and Nagaland Post renouncing Yapthomi blood lineage, which was incorporated at page 165 of the book. Yapthomi Laga Asukuko means the
Come to page 30.
30. Yes, Your Lordship. Settlement order.
What is your name?
Kheuto. Kheuto, Your Lordship. Oh, Hokkaido. Hokkaido. So, Your Lordship, subsequent to this,
How are you involved with this decision?
Lordship,
How are you involved with this decision?
Your Lordship, this is the clan.
Your clan.
Yes, my Lord.
You belong to which clan?
Yapthomi Yemshe.
Huh?
Yapthomi Yemshe. Yemishe. Yemshe clan, that is Yepthomi, and they are the rightful,
You belong to the Yeptomi.
yes, Yemshe, Yepthomi, that's the same. Yemshe is the bloodline of Yepthomi.
But there was no agreement reached in this order.
So your lordship,
And therefore, the joint BB's score declares the settlement between so-and-so descendant and so-and-so descendant as such that the utility belongs to the blood lineage. Where is your name?
your lordship, here, since I'm yet to be appointed, but this judgment, or this decision covers me because I'm from Yemshe clan, your lordship. Then, my lord, I may kindly be allowed to take your lordship to page 38 as well.
Page 36.
38. This is a direct case between the two parties, your lordship.
Who are these? Keto Yeptomi.
Oketo, Yepthomi, yes, your lordship. May I read, my lord, page 38, annexure 6. If I may
Page
kindly be allowed to
39.
read, your lordship.
Yes. Page 36, resignation of so-and-so. Who tenders resignation? J. Ihoto Mon.
Mongzar,
Who? His signature, nothing. in there.
yes, your
Yes,
lordship.
settlement order. Now, what is this? Another one.
This is Z. Ihoto resigning as the GB representing Simiklan because he decided to change his surname and become a member of another tribe, your lordship. He took the identity of another tribe. Hence, on forfeiting his identity, he also resigned from the post, your lordship. May I kindly take your lordship to page 38, annexure 6. Even the properties, the right to property also, your lordship, the right to inherit the properties of Yemshe clan, that was also taken away from Z. Ihoto. If my lord has difficulty, then we can take up before another bench, my lord, since this is to do with Naga customary law.
That is why I'm looking into it.
My lord,
Other matters are always there. I get it here, there. This I didn't have. That is why I'm looking. Now, this document, page 56. You are to be appointed as GB of where?
of Young Zitong village,
Village.
for
Now,
the
can you
semi-tribe,
show me, see, page 57.
my lord.
There are so many GBs, why? Of the same village?
Yes, your lordship, there will be one head GB, the main GB, known as Atokakau in Simi. Atokakau means he is the chief of all the chiefs. Under him, there will
So
be,
every village
yes, your lordship,
has various GBs,
my lord,
and there will be one head GB.
my lord.
And here the petitioner wants to be the head GB. Or
As
just
of
the
now,
GB.
no, to be appointed as a GB. Of course, he is entitled to become the head GB, but he has to be first appointed as a GB, your lordship.
So he has not yet been appointed as a GB.
My lord,
And tell me, how The commissioner appoints the GB on what basis?
On the recommendation of the clan.
No, understood.
Yes, Your
But
Lordship.
what does the commissioner have to do? If it is so much a customary law, what does the commissioner have to do? I'm asking you the reason why. The power has to be there somehow given to the commissioner that he has to appoint. Who, what authority or statute has given him the power to appoint?
Lordship, my apologies on that point because there should be some notification or instruction which I do not know whether my learned friend is ready with that today, but on the next date, I'll try to find some executive instructions. There will be executive instructions, Your Lordship, because this is customary in nature and our Naga customary law is such that it is orally transmitted, Your Lordship. It is not in written.
Kindly come to this page 14 of the affidavit.
The state's affidavit.
In supervision of VR rules for appointment of the Gauhati and operation of VR. While if a person, a permanent resident of so and so 18, they are
Yes.
Yes, this is it.
Executive instruction, yes.
Entitlement to the allowance of the Iman, determination of VR person not convicted, discharged, so and so. Operation of the corporation
yes.
fund, yeah. Constitution of the board. To supervise an operation of the welfare board, the board shall be constituted.
My lord, yes, it starts from page 12.
So this is the thing which is to be done. This gives the power to the commissioner.
Yes, Your Lordship.
Now the question is, when there is already a decision passed by the DBs, by the joint DBs, on the basis of which a representation is given at page 34
My lord.
of your petition, would they not appoint you as the governor?
That is what I'm submitting, and that is also my submission, Your Lordship. And there is another settlement order at page 38. Annexure 6 of my writ petition, Your Lordship. So even the right to inheritance of the property, that
That I
issue
am
is
ready.
already decided, Your
On
Lordship.
further investigation by court, it is found that to be true that they all belong to so and so Isimi estimate land, and therefore as per now the following decision, the divided properties made in so and so that belong to shall remain. Existing properties that is left undivided shall belong to Iman trade and thus does not have any right to claim the properties that belong to Iman even in near future.
Yes, Your Lordship, he was the head GB. Z. Ioto was the head GB on behalf of the Simi tribe.
He was your father.
No, not father, but he belonged to our same clan.
Now, why I find it like this here in this particular document, where to see, let's see here. One document I've seen from, yes, this one, page 44A.
Your Lordship, because they were from the same clan. They were from the same clan, hence
In place of my father.
no, that's why not his actual father, not biological father, but when we are from the same clan. And if by count of generation, if by count of generation that you belong to my, if your lordship belongs to my father's generation, then I would address you as my father.
Oh,
But that's the traditional practice, your lordship.
okay.
If not,
So that means anybody other from the same clan may also claim similar things.
yes, so your lordship, here, the clan recommended the present petitioner. The present petitioner has been recommended to hold the post of GB, which has been,
Denied to you.
yes, and which has already been, the post where Z. Ihoto has tendered resignation, and he has renounced the Simi tribe as well as the Yemshe of Tomi clan. That's why even his right to inheritance has also been taken away from him. All rights have been taken away. And this is an issue with the Simi clan. So it's actually, there is no issue with the Sanctum tribe, though we are two tribes living in the same village. As far as the kingship of the Simi tribe is concerned, your lordship, it is hereditary. It has been institutionalized only recently, your lordship. If not with or without the institutionalization by the government. Traditionally, it is hereditary by bloodline, your lordship. So, my lord, when there are judicial decisions at the village level, Joint DB's Council, the village customary court of Sechung headquartered Nagaland, your lordship, when two judicial decisions are already there, what stops the office of the respondent commissioner's office to appoint the present petitioner and then has been pending, kept his appointment pending for years together, your lordship? Hence, this petition is seeking the intervention of this honorable court.
Now tell me another thing. This one, who is appealing for respondent number 4? Huh? Have the service been affected?
Yes, your lordship.
Because they will be the person.
Lordship, they have,
That village
in
is a-
fact, they have not implemented the necessary party. The Santam GBs will be the necessary party. They have not implemented the.
No,
Santam
your
GBs.
lordship, this
Yes,
is
your
an
lordship,
issue with
here the
the,
issue here, the Simi GBs, they're endorsing the petitioner anyway, your lordship. The objection is coming from the Santam GBs, your lordship. And because of that,
No,
this
no,
case has not been
the-
able to proceed. your
Sometimes the
lordship.
group, if I'm not wrong. So group, they are also a group, both are groups. But the village has a council.
my lord, same
The
council,
village is the party.
my lord.
Who is representing the village? Because the GB would be of that village.
Yes, my lord.
Who is representing, how, has the service been meted out on that?
My lord, the effect of the dusty service notice upon respondent number 4, we have filed on 19/6/2023, my lord.
Hmm.
Service has been deemed complete.
And why is it not appearing?
My lord, it has been more than, I mean, it's been about a year since the service upon the respondent number 4 has been completed, my lord.
So you have closed
It's,
with this village council. Why didn't you ask them to appear?
No, your lordship,
It needs to be village council chairman, the.
You say that you have all the authority with the village, you are hereditary and all these things. Why you are not asking them to appear?
your lordship
If
will
they appear,
kindly,
the things becomes more clear.
Yes, your lordship.
my lord,
Because here, whether, yes, they are to appoint, but the appointment will be an imposition upon the respondent number 4.
your lordship.
Don't you think so? And you have all resources.
No, your lordship, Annexure B of my affidavit filed on 19/6/2023, your lordship. The chairman of the village council has received this notice.
I've seen it.
Yes,
There's
your
no
lordship.
quarrel with that. But the thing is, if they appear, things become better in this matter. You serve it. You have already served it. Why didn't you say that you are hereditary, they are not opposing, are they opposing? They are writing all the letters to you. See, can you see these letters which we have enclosed? These are all requests being made by that village council itself. Can you see? In page 36. This is the request made by this village chairman, didn't it?
Yes, your lordship.
All are giving in your favor. So why you are not asking? And nobody gives in favor of anybody unless they know you very well.
On the basis of the two customary judicial
Understood.
decisions, your lordship.
But the question is how one thing is there, this.
There is one problem, Your Lordship.
1, 2, and 3,
Yes,
in
Your
their affidavit, whatever they have said, but they have enclosed this notification of 2010. You are qualified customary and traditional rights to succession of hereditary systems practicing from so and so. So can we dispose it of directing the state authorities to decide your case, to consider your case for appointment on the basis of the judicial decision which has already come in?
My lord.
Your Lordship, one thing, for, if you look, it's 43 and it's 8 of the writ petition.
Page 43.
Yes, Your Lordship. This will show why the consensus is needed, Your Lordship. Page 43, Your Lordship.
Yes.
The type copy is at page 43A, Your Lordship.
Hmm.
This is the form for settlement of, for
Appointment.
replacement of GB, Your Lordship.
Hmm.
In serial number, I'll read on from serial number 11, Your Lordship. The GB has been proposed by whom? Was there
Where?
and page 43, Your Lordship,
Please.
in serial number 11. It's a type copy. Your
Serial
Lordship.
number?
Serial number 11. The GB has been proposed by whom? And was there a consensus of the village Cal colony? There's a column for that, Your Lordship. This is the form for replacement of GB, Your Lordship. And then there's meeting minutes or memorandum to the effect of the general consensus attached, Your Lordship.
Wait. No, let us read 43A. Is better typed.
Yes, Your Lordship, the whole thing. This is the
Which clause you are referring to?
clause. I'm reading from 11. Your Lordship,
11,
to-
okay.
yes.
The GB has
This,
been proposed by whom? His name?
Yangsitong village.
Okay.
And then.
Was there any
a
general consensus of the village, yes,
Cal
by
colony?
the village Kel or no?
And then 14, meeting minutes or memorandum to the effect of the general consensus attached, Your Lordship. That is why the consensus of all the GBs was required, and in the previous bilaterals, all the.
So you mean to say
Yes, Your Lordship.
that this application which was being submitted
Yes,
was based upon a general consensus
Of
of
the
the
village.
Samtnam as well as the
of the
Sumi
village, Your Lordship.
of the village?
That's why at the first place, the Samtam GP had also endorsed his name, Your Lordship. It's there in the writ petition, Your Lordship. But due to some differences, the Samtam GPs, they withdraw their endorsement as for his appointment as a GP, Your Lordship. That's why the issue arose. That's why the government could not do anything, because there was no consensus, Your Lordship. Because the Samtam GPs, they're adamant on not endorsing his name, Your Lordship. That's why sometimes GPs are also necessary, Your Lordship.
Oh, Your Lordship, my lord will kindly appreciate this. Your Lordship, already 2 customary judicial decisions. They have to challenge that, Your Lordship. Without
that
challenging that,
That is.
Who is going to challenge?
Your Lordship.
Who is going to challenge those decisions?
No, if
They
on the
are
basis
there.
of, if on the basis of one letter,
That those decisions are.
No, the question can be put in this manner.
my lord,
When there are 2 customary courts decisions
yes, Your Lordship.
which have attained finality, can that be the basis for issuing a direction upon the respondents to appoint in view of that notification of 2010? Wherein
Yes, Your
the
Lordship.
notification does not say.
And my lord, what my learned friend is saying is a disputed question of facts and evidence. That's why I'm not replying. If not, the issue on which the complaint arose from the Sanctum side is not because the present petitioner was involved, but apparently there was some blind firing. So on that basis, since they had a change of mind not to recommend the present petitioner, they wrote a complaint letter, but without interfering with the 2 judicial decisions at the customary court, Your Lordship, the district administration, without appreciating the fact that the issue is already settled and there are already 2 judicial decisions. My lord, the appointment has been kept pending for all these years, Your Lordship. But I would not want to raise the issue of a disputed question of facts and evidence here, Your Lordship.
Lordship, those judicial decisions that's pertaining to the SEMA judicial, the sometimes are not involved here.
Oh,
So, yes, Your Lordship.
it's on record. My apologies, Your Lordship. It's on
Because
record.
the-
It's on record. Read the names of the institution on which authority conducted the case
But we're
and
not
who are the
denying,
parties, Your Lordship.
Your Lordship, if the meeting minutes which have been submitted by the petitioner for his appointment is at page 40, Your Lordship, and extra 7, Your Lordship. On the basis of this meeting minutes also, he had proposed his name, Your Lordship, for appointment. And in this meeting minutes, Your Lordship, the Sangtam GP had also signed endorsing his name, and they had withdrawn this letter, Your Lordship, the signatures, Your Lordship. This goes to show that there's no consensus, Your Lordship. And at the first instance, the petitioner banking.
I propose to pass an order asking you to file a proper affidavit. The instant repetition has been filed by the petitioner, claiming and seeking a direction upon the responding authorities to appoint the petitioner as the Gaubura of Yang Tong bracket YZUPU bracket close village with immediate effect. The basis of the claim of the petitioner is that the petitioner is entitled to, on the basis of the customary and traditional rights of succession as a GB, he is entitled to, in terms with the customary and traditional rights, to ascend as a GB Full stop. In addition to that, it is the further case of the petitioner that the joint Dobashi court of Seiyusung and Agunatu had concluded in the settlement order dated, what is it, 29-30/2015.
June 2015.
29-36/2000, June 2015. Thereby declaring that the case between Ilitong oblique Yatuli Achumi descendants and Isimi Itome descendants, and as such that Yutuli Ilitong belongs to the blood lineage of the Imisi. It is the case of the petitioner that pursuant to the said decision of the Dobasi court, there has been various representations also submitted before the before the additional deputy commissioner, before the respondent authorities for appointment of the petitioner as the head GP of Yangzitong village. Full stop. It is also seen that various representations were given, but on account of the respondent authority not taking any steps, and representations were given, and the last being on 27/10/2022. And the respondent authorities having not taken any steps in that regard, the instant petition has been filed. It is further seen that an affidavit in opposition has been filed by the respondent numbers 1, 2, and 3 through the Joint Commissioner, Government of Nagaland, Kohima, wherein it has been mentioned that the Santam community, that the GPs from the Santam community who were the signatories earlier endorsing for appointment of the petitioner as the GB Yangzitong village had in its letter dated 4/2021 had submitted a representation withdrawing the signatures from endorsing the petitioner as the GB. It has also been mentioned that upon receipt of the said representation, an attempt was made to try to settle the matter by holding consultative meetings and general meeting with all the VCMs and the GBs of Yangzitong village. However, no reconciliation happened, for which the matter could not proceed. It has also been stated that on account of the forwarding letter endorsing the petitioner GB having been withheld, had to be withheld in view of the differences between the Santam GB and the Sumi GB. This board, however, finds it very relevant to take note of an notification dated 9th of April 2010, whereby what are the qualifications, disqualifications for being appointed as a GB have been clearly mentioned. From the perusal of those qualifications as well as the disqualifications, one very important aspect is seen that the customary law, customary and traditional rights to succession of hereditary chieftains of the GDs is one of the relevant consideration. Under such circumstances, this court, taking into account the stand which has been taken by the respondent numbers 1, 2, and 3, is of the opinion that an affidavit be sought from the said respondents to clarify as to whether the petitioner, in view of the settlement order of the dated 20, what is that?
29/30 June.
29-30 June 2015, as well as
Lordship, page 38.
the settlement order dated 1/2/2021, and the various representations so submitted from time to time would be entitled to be appointed as a GB even without the concurrence of the Santam GB. List the matter again on 5th of July 2024. The affidavit will be filed by 2nd of July.
Affidavit, Your Lordship, second week of June.
5th of July, they have to file the affidavit by 2nd of July.
My lord. Bless your lordship.
Live has been. Live. for admission, item number 9.
Yes,
May I please, Lordship. In this case, the petitioners, they are approaching this number 4, seeking a direction that state be directed to run MSCP, ACP, Assured Career Progression Scheme, to the graduate teachers. Both of us were brothers from Kerala. Lordship will appreciate in the past till 2000, Naga people we did not have science teacher, maths teacher, Hindi teachers. So therefore, we were appointed in 1981 as graduate teacher in 1981 with science background. Then after serving for more than 12, one completed 12 years, one completed 24 years. But this assured career scheme, progression scheme was not extended to them. This career assured career progression scheme was introduced by Government of India in 1999. Then that was adopted by the state government in 2002. In 2002, when the state government adopted this scheme, it was not granted to the graduate teachers, not only to me, but to graduate teachers. So in the meantime, the two petitioners, they retired from regular service, one in 2005 and one in 2007. Then in 2008,
when were you confirmed?
my lord, confirmation, I'm not sure. Lordship,
That is the most relevant.
page 20. Lordship, may kindly turn to page 23, type copy. Type copy.
Yes.
May I read, my lord? Yes. Orders dated February 2019, 1986, as approved by government by letter number so-and-so dated 6/2/86. The services of the following science and maths teachers are hereby regularized with effect from 1/4/1985.
So you have
Under
been
the-
regularized from 1/4/85.
Yes, madam.
Now, your case is that you are entitled to ECP.
Yes, madam.
Why?
That is all. Because I have completed 12 years of service without any promotion. I completed 12 years in 1997.
At that point of time, that policy was not there.
Correct. Thereafter, central government adopted the policy 1999 to give this benefit to the.
But this is of 2002.
My lord. No, my lord, central government adopted in 1999.
Central government is
Then
different.
state government has adopted in 2002.
Yes.
Therefore, I was denied. Saying that I was denied only on the ground that the graduate teacher had been given higher pay. Therefore, graduate teachers are not entitled. It is not that I have not completed 12 years of service. That is not the case. Or should you see the government affidavit also?
Now, your post, there was a possibility of a promotion.
Yes, very much. From graduate teacher to assistant headmaster. Then it can be either headmaster or SDO,
When
then
did you,
assistant.
this came in 2002.
Yes, madam.
So you, at that point of time, what was your status?
That time I was a graduate teacher.
And then you were entitled to promotion when?
I was entitled to promotion. Actually, after 5 years, one would be eligible, but depending on the vacancy. So now, without any promotion, I had completed 12 years of regular service on.
No, this can be applied retrospectively. Can it be? Finally, see, to avoid genuine stagnation and hardships that may be faced by government employees due to lack of adequate promotional revenue, the government, after careful and hereby introduces the issued period. Two financial upgradations shall be granted under the scheme to Group B and Group C employees. You are Group B and C?
Group A. As per the scheme.
Group A is not here, na?
Not that is the,
Here.
that is the-
The
that is the-
ACP scheme shall not be applicable to Group A.
correct.
Then-
Because of the higher scale. Now Lordship will see the state government has viewed that problem. Lordship will see page next. Government realized of late, Lordship will see page 33. Lordship was putting a question, retrospective, yes, retrospective effect was given. Page 33. The relevant paragraph is, this is Office Memorandum dated 8 April 2008. Extension of the State Assured Career Progressions SCP scheme to graduate teachers under the School Education Department. May I read the whole thing or relevant paragraph, my lord? Paragraph 3, Lordship will see paragraph 3. On a detailed examination of the prevailing exclusion of graduate teachers under the Department of School Education as they were provided a higher scale of pay and designated as senior graduate teacher on completion of 10 years of continuous service as per the provisions of successive ROPs. On a detailed examination of examination of the prevailing exclusion of the graduate teachers from the benefits of the State Assured Career Progression Scheme, it was confirmed that similarly placed teachers under the central government are being covered under their respective Assured Career Progression Scheme. Therefore, after due consideration, the state government hereby extend the provisions of the Career Progression Scheme to graduate teachers under the Department of School Education with the following terms and conditions. Clause 3. The graduate teachers in the scale of pay of rupees 5,000 to 8,000 shall be eligible for the first financial upgradation under the SCP scheme on completion of 12 years of continuous regular service in that grade to the next higher scale in the hierarchy of promotion, that is 6,500 to 10,500.
But you retired in 2007.
Yeah, one was 5, two brothers, one was 5 and one was 7.
But you have retired. prior to
Correct.
this.
I retired in 2005.
And this has not been given retrospective. of-
Correct. This is what I'm challenging. Now, my lord,
You are challenging this.
clause 6.
You are
Clause 6.
challenging this.
Yes, clause 6, my lord. Clause 6. If lordship see clause 6.
You are challenging this of 2008.
Correct,
to the
clause
year
6.
2020,
Clause 6 of 2008, my lord.
23.
Yes, my lord.
Why?
Because by this, in my humble submission, by this, the benefit, the financial benefit has been deprived to me. Because when they issued the first memorandum in 2002, they deprived us illegally, according to them. Realization came in 2008, and no. Exclusion of graduate teacher is illegal, is wrong. So now, therefore, they have issued in 2008. So as for 2008, my humble submission that 2008, there shouldn't be any condition. There should be any condition put in making prospective. If the earlier order was wrong, then it should be it should not be made prospective.
Then why didn't you challenge in 2002?
My lord,
That actually you are challenging the non-inclusion of Group A into that particular ACP.
yes,
In 2002.
correct.
Actually, in 2023. Why didn't you challenge then? How do you get the benefit now? This circular only came up into existence in 2008, post your retirement.
Yes, I agreed about that.
So,
My humble submission is that is
because
only
if
that
we
is the,
start reopening,
that is the only area I'm making my submission. Now, government had realized that their earlier order was wrong.
Government does not realize, government says that we were giving them earlier lot like that, but now taking into account that the central government employees are also getting, we are also giving it.
Correct. So that meaning they have admitted their mistake.
But
My lord,
whatever may
They,
be,
they have admitted.
whatever may be, but then also, if that is there, isn't that a challenge should have been made in 2008 instead of 2023?
That part I agree. My only submission is when government had denied us in 2002, realizing in 2008. So when they realized that it was wrong, then why they make it prospective, not retrospective? That is my only submission. If that area, if lordship comes to finding that my submission is not acceptable, then the matter ends. Because in Nagaland, what happened was in the past, maybe till now, there is no Naga graduate teacher with science background to teach Hindi and science. So either from Assam or Kerala, basically South and from nearby state, they had to bring. So they were made to teach. Then by God's grace, now many Naga people have mastered in science and maths, now maybe Hindi hardly any. So that time they had really given their time and service. Now in old age, these two brothers came. No, we were entitled SCP and MSCP. So therefore, when they came, of course, they came to me very late, no doubt about that. My only submission before this, as I say, coming back to
Because
the same
you
point.
say this, reopening this now at this stage would have far-reaching consequences everywhere. It will lead to a Pandora's box.
My lord, this cannot be made as a precedent. That is one area.
Not only that, it will have, if I give you the same, only I have to hold that their actions on the basis of which was given, because you see the ACP or the MACP schemes are given by the government on its own. They are not mandated. It is on behalf of the stagnation as a model employer, they are taking up that step.
Right.
Now they have earlier categorically excluded group A where you did not challenge it then. Later on, they realized, okay, now let us give it because the central government is also
They are
giving,
also paying.
let us give it.
Similar.
So they have given it in 2008. In the meantime, prior to that, we have retired. Yes.
They have make it prospective, not retrospective. So therefore, why not? When they say why they themselves knew that the past order was wrong, why not make it
No,
retrospective?
they are not saying the past order is wrong.
My lord, that is the.
They are not saying what
it
they are
implied.
saying.
It implied, my lord.
No, that is too much of a subsilence here.
Lordship, that implied had there been no mistake, then the office member, subsequent office member in 2008 doesn't arise. Issuing of 2008 doesn't arise, my lord, unless they realize the mistake.
No, they may, just for example, tomorrow you may very well say, "Well, look here, now they have realized that they should have given the benefit on 10 years, 20 years, and 30 years. Now they are giving it, but they should have given from there. They were making it from 12 years and 24 years. You may say this also. Because now their scheme is 10, 20, and 30. Isn't it?
Right.
So that is a policy. You can't reopen something which is already done. In fact, a very recent judgment has come of the Supreme Court in the case of land acquisition matters. I think 3 days before, it was given by 3 judges. The question arose, you see, you must have heard about the judgment of Pune municipality, wherein it held that if, in terms with section 24(2) of the right to pay compensation, you don't take over the possession or don't pay, then the entire acquisition lapses after 5 years. Okay, that was held by 3 judges. Matter went on 3 judges to women, then the matter was referred to the Constitution Bench. In Indore municipality, it was stated by the Constitution Bench, no, this or has to be read as end. And as such, if possession has been taken or the deposit has been made, a vote has to be there that there has to be no possession as well as no payment for 5 years. Then only you can do it. Otherwise, it would not lapse. So then what happened? Many of the persons are more, this is now the case of DDS. They have made all these things, all have lapsed in view of the Pune municipality judgment. They have now come up and filed petitions before the Supreme Court that now kindly challenging the orders passed by the High Court where it has been held that it has lapsed. And they sought for this. And one of the points which was taken in, can by way of a subsequent judgment or any decision out there, you can allow a review to be taken in respect to the earlier things. Supreme Court said no. Because that is another aspect of the matter which has already come in.
Right.
So this is a very recent judgment from them. But here in your case, they have this is their decision which was taken. That too, this decision was taken when you were already retired.
Correct. That I admit. Factually, that is correct.
Anything to say, Miss?
The group A, he has a misconception. The graduate teacher does not fall under group A. Graduate teachers are getting a higher scale of group C. Yes, that's why they were excluded, Your Lordship.
Huh?
They were ACP were not extended to them in 2002. Only in 2008 it was made extendable to the graduate teacher. In 2008.
So you mean to say that graduate teachers also at that point of time also was not within it,
No.
either in group A, group B or C.
Yes.
They were outside
Yes,
because
they
they
were
were
outside.
getting a higher scale.
Yes. Yes.
But subsequently, in 2008, they were brought in.
Yes. And by that time, the petitioner had already retired. So how can they challenge an older post-retirement, which was past post-retirement? Yes.
Let us dictate. The jurisdiction under Article 2 to 6 of the Constitution have been invoked by two petitioners, challenging the office memorandum dated 8/4/2008, and more particularly clause 6 of the said office memorandum, and further seeking a direction upon the state respondents to extend the benefit of financial upgradation under the ACP scheme to the petitioners in accordance to the office memorandum dated 28/2/2002. The case of the petitioners herein, in short, is that the petitioner number one that both the petitioners were initially appointed teachers in maths and science respectively on contract basis for a period of 3 years in the year 1981 by the Director of School Education. After serving for 3 years, by a common order, the services of the petitioner, along with 59 others, were regularized with effect from 1/4/1985. In the year 1999, the central government came with a policy to introduce the Assured Career Progression Scheme for employees to give financial upliftment to Group B, C, and D employees on completion of 12 years and 24 years of regular service in the case of stagnation or promotion. The state, by issuing a office memorandum on 28/2/2002, whereby benefits were granted to Group B and C employees of financial upgradation on completion of 12 years and 24 years of regular service. It is the case of the petitioner that Group A was excluded in the office memorandum dated 28/2/2002. The further case of the petitioner, as could be discerned from the submission made by Mr. Ajo, is the government of Nagaland in the year 2008 realized that they had committed a mistake and as such had issued the circular, the office memorandum dated 8th of April 2008, whereby the benefit of financial upgradation of financial upgradation on completion of 12 years and 24 years of regular service were also extended to graduate teachers. Graduate, no? Graduate teachers. The legal counsel for the petitioners further submit that in clause 6 of the said office memorandum, the benefit has been given only prospectively. And in the meantime, in 2001, when did you one retire?
2005 and 7.
In the year 2005 and in
And
2007,
Yes.
both the petitioners retired. It is under such circumstances, the instant petition has been filed challenging clause 6 of the office memorandum dated 8/4/2008 and seeking further directions that they should also be granted the benefit in terms of the said office memorandum with effect from 2002. It is also seen that on an earlier occasion, a writ petition was filed in the year 2020, which was however withdrawn with the liberty to file afresh by an order dated 10/3/2023. On the other hand, Ms. V. Shukla, the learned additional advocate general of the state of Nagaland, submits that the petitioners herein having retired even prior to the issuance of the notified office memorandum dated 8/4/2008 cannot challenge the said office memorandum. She additionally submits that graduate teachers were never were not a part of Group A, Group B, or Group C employees. They were kept separate, taking into account that the graduate teachers were getting a higher salary. The learned additional advocate general further submitted that it was only for the first time on 8/4/2008 the government of Nagaland had extended the benefit of the assured career progression scheme to graduate teachers. And in the meantime, as the petitioners have already retired, they cannot now be allowed not only to challenge the said office memorandum, but also to certain benefits which were not there, which were not a part of their service conditions or the government's policy during the time when they were in service. She further submits that the petitioners neither challenged the office memorandum dated 28/2/2002, wherein graduate teachers have been specifically excluded, nor have challenged the office memorandum dated 8/4/2008 till in the year 2023, when the instant writ petition has been filed. She therefore submits that on the ground of delay or laches, the petitioners are not entitled to any relief. Anything else, madam? I've heard the learned counsels appearing on behalf of the petitioners, as well as the counsel appearing on behalf of the respondents and have given due and anxious consideration to their respective submissions. It is an admitted fact that the petitioners herein have retired in the year 2005 and 2007. It is admitted, it is also clear from the plea, from the materials as well as the submissions, that the petitioners at no point of time till date have challenged the office memorandum dated 28 to 2002, whereby graduate teachers have been excluded from the benefit of the assured career progression scheme. The office memorandum dated 8/4/2008 came into existence, thereby granting benefits to graduate teachers of financial upgradation in terms with the assured career progression scheme. It was categorically mentioned in clause number 6 that the said office memorandum dated 8/4/2008 shall be prospective in operation. There is no challenge to the same till the year 2023 when the instant writ petition was filed. And under such circumstances, almost 15 years have passed by. On account of delay and laches in the this court therefore is of the opinion that the instant writ petition therefore suffers from delay and laches. Next. In addition to that, this court also finds it this on merits. Next, on merits also, it is seen that on merits also, if this court duly takes note of the office memorandum dated 28 to 2002, as well as the office memorandum dated 8/4/2008, it would be seen that these office memorandums are policies adopted by the government for the purpose of removing the stagnation on account of lack of remove the stagnation due to lack of adequate promotional avenues. Nothing would be shown that the graduate teachers were at any point of time within the purview of Group A, Group B, or Group C.
Pertains to group B and C, not A. ACP scheme.
Understood.
Yes, yes.
Your submission is also that graduate teachers are not even Group A.
No. Yes.
Nothing has been shown that the graduate teachers fell within the purview of Group A, B, C, or D of the office memorandum dated 28 to 2002. Under such circumstances, it would be seen that the state of Nagaland have only extended the benefit of the office memorandum dated 28 to 2002 to Group B and Group C employees.
Only to the school education department graduate teacher only. undergraduate, only graduate teachers only.
No. 2002.
2002,
It is for group B and group C.
Yes.
And not even to group A and B. It is further seen that the office memorandum, by office memorandum dated 8/4/2008, the state of Nagaland have also extended the benefit of the assured career progression scheme to graduate teachers under the Department of School Education. Taking into account that this is a policy decision on the basis of which the respondent authorities have issued the office memorandum, thereby granting the benefits. The same office memorandum have been cannot be made retrospective by this court. More so at the instance of the petitioners who had retired even before the office memorandum had come into the picture. Therefore, on merits also, the petitioners herein are not entitled to the relief so claimed. So far. Accordingly, this court finds no merit in the instant petition for which the same stands dismissed.
Much obliged. Thus,
For admission, item number 10.
May I please, Lordship,
Senior.
I've received instruction to withdraw the petition with liberty to approach the appropriate forum.
Will you then? Would not say, don't withdraw, I will dismiss it as not intended, I can maintain it, so that you get the liberty. Else your time limit will go, na? There's a limitation problem. Okay. You withdraw, then it will be in difficulty. Okay.
Yes, my Lord, yes, Lordship, please.
I grant you the leave. Heard Swensu, learned counsel appearing on behalf of petitioner. Ms. Swensu appearing on behalf of
Respondent 10.
respondent number 10, Mr. Swensu appearing on the additional advocate general appearing on behalf of the respondent numbers
2, 3, 4, 5, 6,
7.
7.
Mr. Ms. Swensu appearing on behalf of the respondent number 10. The instant petition has been filed by the petitioner being aggrieved for on account of not getting compensation in respect to the lands and or for standing structures of the properties pertaining to the structure number XL17 of serial number 175 and structure number XL22 of serial number 188 respectively, totaling to an amount of rupees 26,75,289.05 in respect to construction of the widening of the two-lane road of NH 129A bracket package 3 from Ferren to Dimapur by the respondents. Pursuant to the filing of the instant writ petition, the respondent number 10 had filed an affidavit in opposition, wherein it has been mentioned categorically that the petitioner have already received the compensation in respect to what the petitioner was actually entitled to. It has also been mentioned that the petitioner is not entitled to any other compensation in as much as the other lands and properties belong to our community lands. From a further perusal of the materials on report, it transpires that the respondent authorities have duly paid the compensation. However, it is a dispute purely between the petitioner and the respondent number 10. Under such circumstances, as the state dispute is purely a civil dispute, the instant writ petition cannot be entertained, taking into account that various disputed questions of facts would arise and the same cannot be adjudicated by way of the jurisdiction under Article 2 to 6 of the Constitution. Accordingly, this court dismisses the instant writ petition. Be that as it may, this court makes it clear that if the petitioner is aggrieved by on account of non-receipt of any compensation, the petitioner would be at liberty, non-receipt of the compensation, the petitioner would be at liberty to avail remedies which are otherwise available under law. with the above the instant.
For admission, item number 11.
May I please your lordship? Lordship, I have an instruction to appear on behalf of respondent 4 and 5. Which your
You
lordship,
want to file affidavit.
yes, lordship. And also Baglat Nama, lordship.
Eh?
Baglat Nama as well as the affidavit in reply, lordship.
Mr. Counsel, what is your good name?
Vic was that, lordship.
Without you appearing from the next time when I see you from a distance only, I can make out that your submission will be, I'll file my Vakalatnama and file like that.
My
Because
sincere
this is the fourth time the same submission has been made from yesterday. When did you file, when did you get your service of notice? When did you receive? We are appearing for 4 and 5.
4 and 5, lordship.
Lordship, in fact, they first
If
appeared
we see
on
this,
7th of March. They first appeared.
Mr. V. Koza,
Lordship.
9-5. Mr. V. Koza, learned counsel appearing on so and area appears on behalf of respondent. Submits 3 weeks time to file affidavit in order. Then what is this? Heard Mr. V. Marhu, learned counsel for respondent who creates time for listing the matter for filing affidavit. What is this?
Lordship, last sense may be clear.
What is the matter, madam?
Lordship, here we are challenging the tentative seniority list of the LDA computer assistant. There are other private respondents also. They are already represented and some of them have filed their counter as well. Lordship.
You are who?
Lordship, I'm for the petitioners.
No, understood.
Lordship,
what is it?
I'm also serving as an LDA computer assistant. Lordship. However, Lordship, I was appointed accordance with the service rules. Lordship, open recruitment through NPSC. Lordship. However, the respondents they were appointed without any selection process. Lordship.
They have been appointed how?
Lordship, they were appointed on contract on casual and contract basis. Lordship.
Now they are higher in the merit list.
Yes,
seniority
Lordship.
list.
They are yes, Lordship. They are placed higher than.
Yes, Robin.
My lord, I'm appearing for on behalf of KM State Council for the state.
What do you want?
The-
Not him. Don't
the
know. He has not
respondent,
filed
they
a
are-
Vakalatnama.
They are yet to file.
I'm not concerned. We'll pass it on the file. 3 times they have already taken it on. So we consider that they don't need it.
He's not
Who is
here.
appearing for the state?
KM, yes, my lord. I'm mentioning only his behalf.
Then?
So,
You have already filed your affidavit. in the
yes,
police.
my lord.
Then we take up the matter for disposal. What is
My
your?
lord, then let the matter will come up next week, my lord.
Why?
Because that council who is handling the case is not.
Lordship, if I'm not mistaken, I think state is yet to file their counter. Lordship.
What is the state's affidavit?
Lordship, apologies, Lordship. They have filed. My apology, Lordship. I do not have a copy of their counter, Lordship. They have served us a copy, Lordship. However, my senior has the complete briefs, Lordship.
State has filed an
Yes,
affidavit.
Lordship. Yes, Lordship.
You don't have
We
a
have
copy.
received it. No, Lordship.
Then have you filed a reply?
No, not yet, Lordship.
You want to file a reply?
Lordship, if I
Okay,
do
Ms.
not have.
So-and-so, appearing on behalf of the petitioner, submits the though an affidavit in opposition has been filed by the state respondents. You have the copy of the other affidavits?
Yes, Lordship. Yes, Lordship.
Affidavit has been filed by the state respondents. But she had not, somebody had received it, LR something.
Lordship, we were served the copy, Lordship. However, I don't have the complete brief with me. It's with my
Today?
senior. Yes, Lordship. I don't
You
have
want
it
to
with me
file a
today.
reply?
Lordship, I will have to get instructions for that. Yes, Lordship, if necessary, I will.
When so the learned counsel appearing on behalf of the petitioner submits that to take instructions as to whether the petitioners would like to file a reply to the affidavit in opposition filed by the respondent numbers 1, 2, 3, and 10. It is seen that Mr. B. Koza, the learned counsel appears on behalf of the respondent number 4 and 5 and has submitted that she would like to file as well as also file. It is seen from the records that the respondent number 5 have been duly represented since 16/4/2024 by various counsels. In fact, on 9/5/2024, a similar submission have been made by Mr. D. Koza. Under such circumstances, this court grants a final opportunity to the respondent number 4 and 5 to file their affidavit, as well as let this matter be listed on again on 5th of July 2024. In the meantime, the petitioner shall file the, if so advised, shall file the affidavit in reply by 2nd of July 2024. It is made clear that the respondent number 4 and 5 would be at liberty to file their affidavit by 2nd of July 2024. It is made clear, however, if the respondent number 4 and 5 fails to file such affidavit, then the said instant matter shall proceed in absence of any affidavit filed by, in absence of a counter of the respondent.
For admission, item number 12.
Please, Your Lordship. Your Lordship, I'm here to file my affidavit in reply. So kindly grant me 3 weeks time to file reply.
You have taken 2 adjournments.
Yes, Your Lordship. Your Lordship, I'm yet to obtain instructions from my client.
I think your petitioner does not want to file.
Uh,
What is this case you are?
Your Lordship, the matter pertains to land ownership, appointment on land ownership.
Then, if you are not filing, then what is left?
The respondent number 5 in their affidavit, they have stated that he's also one of the landowners, whereas our claim is that he's not the landowner.
So you have not filed your affidavit in opposition. It was filed in the month of March. We are in the month of June.
Yes,
So
so
why is you have taken it?
Your Lordship, there is a
Will
dispute.
permit you subject to cost to be deposited. Speak to him. He's appearing.
May I please,
10,000?
may I please, Your Lordship, my lord, appearing on behalf of Livika, State Council. She's not here, so.
Okay, you take the money.
Your Lordship, there is a dispute between the petitioner and the respondent number 5 about the landowner. So I need proper clarification from my client to file the
Affidavit has been
affidavit.
filed already in the month of March. We are in the month of June.
Your Lordship,
Twice
this
we
may
have
be the
taken
last
adjournment.
chance.
If you don't think the other courts permit, I do. The counsel for the petitioner submits that a final opportunity may be granted to her, to the petitioner for filing the reply to the affidavit in opposition filed by the respondents. Taking into account the above. This court have duly taken note of that on 11. on 11/3/2024, 9/4/2024, 2/5/2024. Similar prayers have been made by the petitioner. Taking into account for the ends of justice, this court grants a final opportunity to file the affidavits in reply on or before 24th of June 2024. This is the matter again on 27th of June 2000.
Much obliged.
For admission, item number 13.
May I please your lordship? I'm appearing on behalf of respondent number 3, 4, 5, and 6, who is the Nodal Department for implementing the scheme lordship. In the last order dated 9/5/2024, though it is not reflected in the order, the petitioners were given to clarify to the court as to whether the LLB course and the LLM course are equivalent or not, since they have mentioned that
Who is
LLB.
appearing for the union? Because last time Mr. Yangavati had taken time
Lordship,
for filing something.
lordship,
Has he filed? No.
not yet, lordship. And there's an urgency in the matter for disposal because exam is held for 1 year, lordship.
Huh?
For a period of 1 year, the exam is already held. This is a scheme, this is a project under the scheme Mission Vatsalya, lordship, with regard to the appointment of district child protection officers and the following posts, lordship.
Exams are over?
No, no. Exam result is reserved. The preliminary result is reserved due to the petitioner coming to the court, wherein they are challenging only the advertisement serial number 4, wherein the age criteria is entered as 21 to 35 years, which is read with the Nagaland notification, state notification. However, in the Mission Vatsalya scheme, the age is not mentioned. But in the provision, there is a provision for the state implementing agency to exercise accordingly for the full implementation of the scheme. So accordingly, the age criteria was entered in the advertisement. And that is the reason why the petitioners came to the court aggrieved with the age bar.
Where is the age mentioned in the advertisement?
Advertisement 14 July 2023 petition, page number 34, lordship.
Page 21?
34. 34, annexure G.
34.
Annexure G, lordship. Annexure G, page number 34. This is the amended petition. They have amended the petition.
Amended petition?
Lordship, lordship.
Page 34.
Page 34. Annexure G. Point number 4, lordship, under the terms and conditions. Point number 4, it says the
Should be
applicant.
21 to 35 years of age. The
Lordship.
age relaxation for in-service shall be as per the existing norms of the state. So what is wrong?
Lordship, here the implementing department has put the age criteria, but in the guidelines, for of Mission Vatsalya, under the provision of 2.4p, it says roles and responsibilities.
Where do I get that?
Lordship, I will submit it.
This one?
Lordship. Page
Lord-
number 8.
Huh?
Page number 8. Page number 8. B, down bottom. B, roles and responsibilities of the state mission director in SCPS. Point number 1, it says to take all administrative decisions pertaining to the implementation of the Mission Vatsalya and related fund disbursement and maintaining oversight and supervisions on implementation of the scheme in all the districts of the state, lordship. So in read with this provision, the implementing agency, the mission director has exercised and put on the criteria, read with the Nagaland notification of the age criteria. However, the petitioners are all above the age criteria, that is 40 plus only, and they don't fall under the advertisement. So they are aggrieved with the age part being inserted in the advertisement. But they have not challenged the all guideline, Lordship.
Here it does not say anything about the age.
Lordship. The guidelines is silent, and so exercising the provision given to the mission director, in the advertisement for implementation of the scheme, they put on the age criteria, and that is also read with the Nagaland notification, Lordship, which I have already filed my comprehensive reply, Lordship, affidavit in opposition, Lordship. Also, I raised my preliminary objection also, Lordship.
Where is your affidavit?
My lord, if my lord may kindly appreciate the last order, the union is supposed to file an affidavit on.
Union, they don't file, no one is appearing, so how does it matter? This is what post? Grade 1, grade 2, grade 3, grade 4? What is this type of post?
Lordship, these are all on contract basis only. This is in the scheme implementing for the children, Lordship, district child protection officers. And subsequently with the protection officers, non-institutional care. And so all the petitioners, the 6 petitioners are serving us. They were serving, Lordship, in fact. They were serving as protection officers. And so now they want to apply for the DCPU, which is one step higher, Lordship. However, the criteria is not enabling them to apply for that.
Who are you?
Your lordship, we are presently serving as the legal cum probationer officers.
They were serving lordship. They are
No,
no more
why,
in the
we
job.
were serving.
why,
yes.
Mr. Joshua, you have not mentioned in your affidavit what is your age? Or even in the petition?
My apologies, your lordship, that is an oversight.
This is a very important aspect when you are challenging on the question of age. Why in the entire petition there is no mention that you are overage? You are only challenging that, how do you have a locus?
Your lordship, the fact is all of us are overaged.
What? No, where have you stated out here that you have 40 years? No mention, nothing. How do you have a locus to challenge that clause then? And more particularly when your affidavit is silent. I would have understood the affidavit. Why are you challenging that? If you
Your
are,
lordship, as far as the paragraph 12 of my petition is concerned, as far as the guideline is concerned, there is no age bar.
that is a different
So-
thing. Why will you challenge the age if you are not overage? Where is your statement that you are overage? You are everywhere saying that 21, 30, 21, 35, 21, 35. Where is it that you are saying that you have crossed 35? As you mentioned, not there. That is what I could see.
No lordship. Even the qualification
The
required by
petition
the,
doesn't seem to be.
Lordship, going by the guidelines, there was no requirement to make a specific mention of the age of the.
They may. They can have the age. That is within their domain to them because the entire burden, the entire responsibility has been given to them. They are going to have it in the state health commission, health mission, na?
Mission Vatsalya. That is under social welfare department.
It is a society or something.
Lordship.
Okay, whatever may be, they want to do it. The responsibility have been given, and they can't have more than that. The moment you have more than that, tomorrow again they will come up with anything. If it is an advertisement by them, and tomorrow they make it 40, another petition will be filed by you only, stating that look here, 21 to 35 is the age which is the government's age. How can they make it 40? Tell me. And where is otherwise, if you don't put the age, what you are submitting is it's the problem which will happen. If you don't put the age, a 60-year-old can very well apply.
Your lordship, in some other states, of course, the
Which
state
is
also has
show
the
me any
discretion.
advertisement
Yes.
as regards the selection to a particular post where there is no age. Have you ever come across any?
No, your lordship, but under the mission Vatsalya, under the same mission in the other states, they appoint those who are up to 55 to 60 also, your lordship. Here, we are all overaged.
But
As far as 21 to
understood.
35 is concerned.
You could have said only one thing. There should have been a relaxation given for those who have been working in the same department or in the same society. That would have been half case made out.
True, your lordship.
Because normally what happens, if you see in most of the advertisements, it is said that if somebody is being working in a particular department on ad hoc or anything, they are also being considered and that period of service is taken out, but maximum period admissible is 5 years. And this is more particularly in all Nagaland. This is how it is.
Your lordship, there were some instances in the department also. Who were
First
in
of all,
the-
your petition should be dismissed on that ground itself. You have not put the age.
If my lord may kindly appreciate this.
I can't
Now-
appreciate anything.
Lordship is not about the
See
age.
the
also.
guideline.
Even the educational qualification, they are not qualified. If you have to see the other lens also.
The
it's
other
not
things
for
we are
age also.
not, but the question is without stating that they are overage, what is the locus to challenge their age?
Exactly, Lordship.
It doesn't show that you are bona fides.
Lordship, I've raised that in my preliminary objection also, Lordship.
You have to take the age. Why haven't you mentioned? Why you are
Lordship,
challenging our
specifically
age?
what we have challenged is
And what
that
you are asking is very difficult.
the age bar should not be within 21 to 35 years. And I had some other
No,
mission,
they are doing it 21 to 35 is because of the fact that it is the mandate of the government of Nagaland. It's a notification of the government of Nagaland because you see, the
your lordship will kindly take
all
note of this.
governments have a power to grant or state the age. That is there. They may give relaxation to SC, ST, whatever may be OBC or all, in exercise of the powers under Article 16(4), Indus 1. They can very well give it. So therefore, that relaxation is, which is also given, is also a form of a reservation, which is being given. Now, in this case, you have not stated that you are overage.
Your lordship, they are not state government employees. They are employees under the central scheme under a society, your lordship. So my lord, whether the first bar which, in my humble knowledge, to overcome was whether 21 to 35 is reasonable or not. And
Can they put more than that when the state of Nagaland is doing it? Because the responsibility has been given to the state of
under the
Nagaland.
mission Vatsalya,
They would be tomorrow violating their own rules. They
I
have a
was
particular
about to
criteria.
present before your lordship some other states' documents. But your lordship, we specifically have not mentioned the age of the petitioners, your lordship.
You don't have a case, Mr. Joshi.
Your lordship, I may be allowed to present a document of the Himachal Pradesh where they are making an advertisement for district child protection officer. In their understanding, these are to be manned by people with sufficient experience working in the field, not some youngsters between the age of 21 to 35 who doesn't have an experience. So for district child protection officer, if we are to take the example of Himachal Pradesh, 58 to 62 years of age. I was of the impression this honorable court would arrive to a reasonable conclusion that this age bar would be the limit. Then the petitioners can either apply or cannot apply. That would depend on the decision of this honorable court.
Lordship may kindly appreciate, even if the petitioners,
And why all the petitioners are belonging to what? All are applying for this legal cum probation officer.
No, not only that, your lordship, for the post of the district child protection officer also, but here the state has disputed, and my learned sister, as she has already submitted, that according to the qualification required, according to the state respondents, we are not qualified because we are LLB. Most of us are LLB. I think one
LLB,
LLB.
bachelors in law.
lawyers.
Yes, your lordship,
Then
lawyers.
What
So
is
my
the
lord,
requirement? Educational qualification is what?
according to the state respondents, my lord, it should
Eligibility
be
criteria can be
masters.
downloaded. Where do we get this, madam? Annexure G, that thing, the downloaded copy? Is
Lordship,
this- This one?
Lordship, the guidelines, Lordship.
Where is
Page
the
number
where is the
61.
eligibility criteria?
Page number 61, Lordship.
60.
61, Lordship.
The guidelines.
Okay.
Lordship, as mentioned by the
Postgraduate in social work, so and so, they are law. Law is
61.
there? Postgraduate? No,
The required
Postgraduate.
qualification is postgraduate, which means
In
LLM,
social work, sociology,
not a graduate.
postgraduate, Lordship.
You need an LLM.
And all the petitioners don't fall under
my lord,
LLM, Lordship.
there are two possibilities, my lord, if my lord may kindly appreciate. When we pursue LLB after BA, that is also considered as a postgraduate course. And the scholarship by the government is also paid according to the postgraduate course, Your Lordship. So the petitioners are of the
No, you
impression
apply
that
for this protection officer institutional care. There it is permissible, graduate in social engineering, law also. Oh, salary is less.
Your Lordship.
Now you don't say, for what do you want?
Oh, my Lord,
Now what post you are aiming at?
in fact, the
Have you
petitioners are
stated in
mostly
your petition?
interested in
No.
the item
That is
number
also
one.
not stated. What do you want?
Your Lordship, mainly is the age.
Age, first of all, you don't say what is the age, your age.
Your Lordship, all the petitioners are of age. That's why we're
How do
questioning
we
the
know?
21 to 35.
Now, how do we know that your age is more?
They're
And
not-
if this is there, have you challenged this circular? This thing, that they have postgraduate degree in law?
Your Lordship,
Because when they use graduate also in the same year in the next one means LLB. For district child protection officer, district means he is overall one post.
But this advertisement is confined only to the newly district being formed.
So
Only the
it's a
5
very
new
important
districts.
purpose. He's like the district judge, deputy commissioner. So they need a LLM.
Madam.
You are
Your
not
Lordship,
saying
if the age must be shown, then I may be allowed to file an additional affidavit within a
But
period
how
of
do
few
you
days.
take care? Okay, we allow you. How do you take care of these? The other one. Which post do you want?
As far as the post is concerned, Your Lordship, there are many
Which
posts.
post?
And all the salaries.
No, Mr.
No, my Lord,
You cannot come up like this in this manner. It's too vague a petition.
my Lord, may kindly have a look at
There
the,
is requirement. Mr. Joshua, I think you need to instruct your juniors to draft your petition properly.
my Lord, may kindly have a look at the first advertisement, which I have annexed with my writ petition.
Uh,
The payment is 12,000. Relevant page is a page 22, Your Lordship. Page 22, serial number 4, legal cum probation officer. Now this is 12,000. Now if we come to the new advertisement, my Lord will see that even the amount has been enhanced.
Yes, what do you mean to say? So you mean to say in this case, there was no age mentioned?
Lordship, the petitioners were appointed in the old guidelines, Lordship. And this advertisement is covered by the new guideline, which will be applicable from 1st April 2022, Lordship. So the old guideline is not relevant, Lordship, in this present advertisement, Lordship.
Okay, you have been able to stall the appointment for 1 year. That is the happiness you should get.
And Lordship, the exam is held for 1 year, Lordship.
Huh?
The exam is already held for 1 year, Lordship.
Understood. So he have been able to stall for 1 year. That is the happiness. No case.
Lordship.
Which post do you want? If you have not stated, you can't make it. The petition can't be so vague. The problem arises. I will dismiss it not on the ground, the other ground, not on that 40 you have not stated, because that shows the drafting has not been done. I won't do that. But I will do it on the ground that you have not challenged that.
Lordship.
And in terms with the age, it is okay. In terms with this, I will say. I won't say on that because otherwise it shows the inefficiency of the person who drafted. But you can stall a selection process for long because this will have an impact. There is one post which is dealt with. Well, let's repeat. In Guwahati, on a lighter note, if you get a sound of like this of rains, people fear, would they be able to go home with this type of rains? Because there would be floods.
Lordship,
Anyway, the petitioners who are 5 in number, 6 in number, has approached this court by filing the present writ petition challenging the advertisement dated 14/7/2023 issued by the Department of Social Welfare Nagaland, Kohima, thereby inviting qualified candidates on contractual basis under the Mission Vatsalya scheme, and also seeking a direction that the petitioner be allowed to apply for those posts. From a perusal of the writ petition, it reveals that the sole challenge made to the advertisement dated 14/7/2023 is on the ground, is in respect to the clause 4 of the said advertisement, wherein it has been mentioned that the applicant should be 21-35 years of age. It has also been mentioned that the age relaxation for the in-service candidates shall be as per the existing norms of the state government, which is normally 5 years it is given.
I beg your lordship to kindly include one of my submission. The DCPO is to be appointed before the other posts are appointed, your lordship. Here, the DCPO is also advertised along with all the other posts. DCPO is supposed to be part of the interview group. To lordship.
For you to say that doesn't suit. You are a candidate. Who will be there? First, you have to be eligible. No? To be eligible, then you can say many things.
Lordship.
You need to first cross that hurdle.
Madam,
We will see later on.
lordship.
It is the case of a petitioner wherein that this clause, that similar clauses were not there in the earlier advertisements. And by incorporating those clauses, the said clause, thereby limiting the age to only 21-35 years of age, would deprive the petitioners from applying to the post, as well as also would not be in the interest of the as well as also would not be in the interest of the scheme for which the appointments have been sought to be made. Mr. J. Seki, the learned counsel appearing on behalf of the petitioner, submits that posts like District Child Protection Officer, Protection Officer Institutional Care, Legal cum Probation Officer are posts which ought to be manned by persons with experience. And as such, the limiting of the clause 4, and as such, the advertisement whereby the applicant's age have been constricted to within 21 to 35 years of age would not be in the interest of the said scheme. On the other hand, Ms. So-and-so, the learned government, which the learned counsel appearing on behalf of the respondent number 3, 4, 5, and 6. How many?
Lordship, 3, 4, 5, and 6.
And
Lordship.
6. And 6. Submits that the age limit have been put in the advertisement in accordance with the office memorandum of the government of Nagaland dated 30/11/2007, which categorically stipulates that the age limit would be from 21 to 35 years in respect of grade 1, grade 2, and grade 3. Full stop. It is also mentioned that as per the said office memorandum, age concession for serving government employees will be allowed, the equal number of years they are in service subject to a maximum of 5 years. The Learned Council also submitted that there is also an upper age limit for physically handicapped persons, which is relaxable by another 10 years. It is therefore the submission of the Learned Council appearing on behalf of the respondent number 3 to 3, 4, 5, 4, 5, and 6 that there is no infirmity in the said advertisement, and more so in respect to clause 4 of the said advertisement. The Learned Council further, during the course of the hearing, drew the attention of this court to the detailed eligibility criteria, qualifications and work experience requisite for each post, which is available in the department's website, and placed before this court the mission Vatsalya guidelines. The Learned Council submitted that a perusal of clause 2.4 B, capital B, shows that the government of India have endorsed all administrative decisions pertaining to the implementation of the mission Vatsalya and related fund disbursement and maintaining oversight and supervision on implementation of the mission in all districts upon the state mission director. The Learned Council therefore submits that in that view of the matter, the respondents herein have taken into account the notification office memorandum of the government of dated 30/11/2007 and thereby have put the age limit in the advertisement. The Legal Counsel further submitted that the petitioners herein are also not qualified. Otherwise also further submitted that the petitioners herein are otherwise also not qualified, inasmuch as for the post of District Child Protection Officer, the eligibility criteria is postgraduate degree in various disciplines, including law. Full stop. In the instant case, the petitioners herein are only law graduates. Full stop. The learned counsel further submitted that in absence of a challenge to those guidelines, the instant writ petition therefore cannot be maintained at the instance of the petitioners. So, upon hearing the learned counsel appearing on behalf of the parties, this court had put a specific query upon the learned counsel appearing on behalf of the petitioner as to which post the petitioners would like to apply in pursuant to the advertisements. Mr.
Your Lordship, in all the posts where they are eligible, and most preferably the first post, but Your Lordship,
Mr. Joe. Which post? Because you are already, this one, not legal cum probation officer.
yes, Your Lordship,
You are already there.
Lordship.
Salary is almost same. So you would obviously like to go for the DCPO.
Your Lordship, in fact, that was the target, and also I was pointing out on the DCPO cannot be actually advertised along with the other posts. If we go by the guidelines, so
That is
that was
another
also there.
aspect. Another aspect. But where you want to apply?
But to raise that issue, Your Lordship,
Let us see your
qualification aspect,
answer.
my Lord.
It's a very clever answers which you given.
Lordship,
not
the
to post.
petitioners may not like to go to data operator when they are already in the higher post, Lordship.
Lordship.
So above, only above them is a DCPU only, Lordship.
Well, they have submitted a representation. Let us see where. I've seen it somewhere they've given a representation. Yes, there. It appears. To the specific query, the learned counsel for the petitioner submitted that the petitioner would like to apply to those posts where the petitioners are eligible. This court, under such circumstances, that this court, taking into account the said evasive reply, had taken note of the representations were submitted by the petitioners on 27/2023, which is a part of the writ petition. From a perusal thereof, it reveals that the petitioners herein are interested to the post of the District Child Protection Unit, isn't it? No, yes, District Child Protection
Officer, Your Lordship.
Officer.
Your Lordship.
Officer. Full stop. Next. This court further have taken note of. This court have duly heard the learned counsel. This court, upon hearing the learned counsels appearing on behalf of the parties, have also given due consideration to their respective submissions. This, from a perusal of the guidelines of Mission Vatsalya Mission Vatsalya, there is no mention, however, as regards the age limit. Be that as it may, from a perusal of clause 2.4b, the responsibility have been given to the State Child Protection Society to take steps for implementation of the said scheme, being Mission Vatsalya. This court have also taken note of the office memorandum dated 30/11/2007, wherein the government of Nagaland in the Department of Personal and Administrative Reforms have fixed the upper and the lower age limits to enter government services for different categories. It appears that for grade 1 to grade 3, the age is 21 to 35 years. And in respect to grade 4, it is 18 to 35 years. It is further seen that for general candidates, the upper age limit would be 30 years. And age concession for serving government employees would be allowed the equal number of years and up to a maximum of 5 years. It is also seen that the upper age limit for physically handicapped persons would be relaxable by another 10 years. It is the specific case of the respondent numbers 3 to 6, that basing upon the said office memorandum, the clause 4 have been inserted in the advertisement. This court is of the opinion that the said cannot be said to be in any manner unreasonable or unfair for the purpose of exercising the jurisdiction of this court. This court further takes note of that the petitioners herein are interested to apply for the post of district, that officer education district
District Child Protection Officer, Your Lordship.
officer, wherein it has been categorically mandated that the educational qualification would be postgraduate in various disciplines, including law. Though Mr. J. Seki, the learned counsel appearing on behalf of the petitioner, had submitted that an LLB degree is considered to be a postgraduate degree. But this court, taking into account that in respect of other posts, for example, protection officer bracket institutional care, the guidelines specifically stipulate graduate in various disciplines, including law. The guidelines therefore envisage that the eligibility criteria has to be for the post of district child protection officer would be postgraduate in various disciplines, including law. Admittedly, herein, the petitioners are only law graduates, and as such, the petitioners would not be qualified even if permitted to apply to the post of district child protection officer. Consequently, in view of the above, this court finds no merit in the instant petition, for which the instant petition stands dismissed. Interim orders, if any, stands vacated.
Obliged, Your Lordship.
Obliged, Lordship.
For admission, item number 14.
Mr. Seki, you need to ask your juniors to be more careful.
My lord.
This is a very vital thing which have been done. You have not put the age. Isn't it a question of locus?
My lord.
This will poorly show on the area, so I am not putting it. This is a very important thing. You have to be careful.
Obliged, Your Lordship.
Yes, what is this? Affidavit in reply
May I
not
please, Your
filed.
Lordship? Kindly allow me 3 weeks to file affidavit in reply.
Why?
As my senior counsel is on leave, as reflected in the daily cost
Senior
list.
counsel, what is the senior counsel doing? Every time you are asking for time. I pass a direction on the basis of which he files the affidavit. And thereupon you are silent. What to do? Absolutely silent.
Lordship, actually, in the previous occasion, the petitioner was out of station, and this time my senior counsel is on leave since he has a personal problem.
Mr. B. Zinomi, what case is there? Do they have a case?
This is to do with premature retirement.
Is that 30 years? 30 years,
35.
35 years.
No.
I think we should give an additional opportunity, last one. When? How much
2 weeks.
date?
Lordship, I can't fix a date.
You have to. 2 weeks doesn't mean that 4 weeks. Date. Okay, you give you the last opportunity, 24th of June. Okay? Or 28th of June, 28th. Filed by 28th of June. Last opportunity. Full stop. The counsel appearing on behalf of the petitioner has sought for time for filing the affidavit in reply. Full stop. It is noticed that on various occasions time had been sought. Under such circumstances, this court grants a final opportunity to file their reply by 2nd of July 2024. Failure to do so, this court shall proceed on the basis of the materials which are otherwise available on record. List the matter on 4th of July 2024.
For admission, item number 15.
May it please, my lord. Lordship, I have received the documents which I have been waiting for this week, Lordship, and the reply is already under drafting, Lordship. As such, I may kindly be
Under
drafting. It's
They can be issued the last order. No further, because they are sought for 2 weeks.
last order is what? I
Last
have
order-
considered submission for both sides and make clear that no further adjournment will be given to the petition.
yes,
You have
Lordship.
stay- You've got a stay.
No, Lordship.
What does he want?
So, Lordship, here they are challenging the notification issued by the government, barring the government advocate from doing private practice.
Government doctors, not
Government
expert.
doctors.
Huh?
Government doctors
Government doctors.
from doing private practice. Now they are getting non-practicing allowance. In lieu of not to.
They are challenging that.
Yes. And they are the doctors who are getting NPA. That is 40% of the basic pay as an entitlement, Lordship. And this is pensionary. It goes in the pension also. Pensionary annulment. Now, beyond the notifications, Lordship, the Nagaland government has framed the Nagaland Healthcare Establishment Act, which provides for establishment of private establishments.
You have the option of leaving the job.
Lordship,
Exactly.
Lordship, there is more to this case than meets the eye, Lordship, because Lordship, this shall have consequences.
In Assam, the doctors want to leave the job.
Yes, Lordship, in Nagaland also, Lordship, that is there, Lordship, but here in Nagaland, the issue is, Lordship, the government-run medical facilities and institutions, Lordship, except for the institution in Kohima. The others are very poorly managed, Lordship, and there are no proper facilities, Lordship, and it is on the public demand and the request made by the public, Lordship, that the government doctors are compelled by their circumstances to give their service while they are not working in the private institutions,
Okay,
Lordship.
you give an undertaking that if you have to do, you'll do it free of cost, because you're already receiving from the government.
Yes, Lordship. Yes, Lordship.
What do you say?
Lordship,
If he say, his case, his submission is this, then look here, Kohima, okay. But in various other places, the government institutions do not have proper facilities. No, his submission. And as such, the public get hold of these doctors and ask them to perform, to do or give their services, and under compulsion, they do it. I said, okay, very well, you do it. There's no pro bono, anybody can do it. Yes. But do it free of cost.
Lordship will be happy to Lordship. In fact, Lordship, against the memorandum,
I doubt, Lordship, I doubt.
against the memorandum that is under challenge here, Lordship.
I doubt, Lordship. Now, Lordship, there was a complaint lodged by the Nagaland Medical Council, a statutory body, saying that there's been rampant private practice going on in the state.
Wait one thing, Mr.
Yes, Lordship.
His reply is in the computer. So let him take out the printout and file it next week.
Yes.
After 2 weeks, Lordship. Kindly,
You said it is in the process of being drafting.
Yes, Lordship. But to be on the safe side, Lordship.
So,
No,
Kindly
Lordship,
2 weeks. Lordship,
earlier also I've
that's
taken
simply,
time.
Lordship, what my learned friend is trying to portray. It's not even in the pleading.
Huh?
It's not even in the pleading. Now, Lordship, by the Act, Section 8, Section 8(1)(c). I've marked it, Lordship, which provides that no private establishment, that is healthcare establishment, shall engage government doctors, nurses, and other paramedics who are employed with the government. And this is an act, Lordship.
So you have not challenged this?
no. Lordship,
No.
we are only challenging the.
No. Without challenging this, you cannot override.
Lordship, we are.
Notification is in pursuance to this.
Lordship,
So-
only the office memorandum, we are only aggrieved by the office memorandum, Lordship, because
No,
Lordship, it is.
you cannot. You see,
Lordship-
no doctors, nurses, or any paramedics or any other employees in the employment of the state government shall be employed in such healthcare establishments. And what are those such healthcare establishments are?
Lordship, this private.
Somewhere defined.
Lordship, you can't come to the definition, Lordship.
Huh?
The definition.
Yeah, healthcare. 40. Yeah. No, section 3. A general hospital, any institution, a clinic where patients are admitted, so and so. So, and in view of this, section 3 and read with section 8,
Yes.
you have cannot, unless you challenge it.
Lordship, I am in
Withdraw.
this. No,
Withdraw
Lordship-
with liberty to challenge this.
Yes.
You have
Lord-
no other option without
Lordship,
challenging.
I am only aggrieved by the OM, Lordship.
So, then it is very good.
Lordship,
Let me dismiss it.
no, Lordship,
Dismiss it if you are only challenging the office memorandum without challenging.
I may be given a chance, Lordship, to file my reply, Lordship.
No. Matter of where is the office memorandum which is challenging.
It is at Annexure 3.
Page
68.
68.
They are aggrieved by clause 1, 2, and 3.
1, 3.
1, 2,
1, 3, and 4, Lordship.
2, and 4.
1, 3, and 4.
Who are not dealing NPN involved in private practice. What is NPA?
Non-practicing allowance.
Okay, within 1 month from the inside both availing as well as not availing. Okay,
Lordship, just one, Lordship, one point.
this is the act.
Yes, this is the act. It's called the healthcare establishment. Now, Lordship, this has been issued in pursuance to the Act, Lordship, and in view of the complaint lodged by the Nagaland Medical Council before the Nagaland Lokaयुktha. It has been found out that maximum
No,
doctors.
hold on. The only thing is, we need to we dismiss it on this ground that this is covered.
No, Lordship.
You cannot. Matters. You withdraw with liberty to file challenging this. It is the only way. Or if you.
My lord, in that
Because
case.
I'm telling you,
Yes,
like
my lord.
many cases today I've seen, there are matters where, just for example, contingency workers.
Yes, Lord.
Mr. Seki has given, that unless you challenge the office memorandum, you cannot get the benefit of
Yes,
it.
Lordship.
The petitioners herein, how many?
51 of them.
Good for you.
Yes.
The petitioners herein have challenged the office memorandum dated 31/7/2023, whereby the Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department have issued certain instructions to the effect that the in-service doctors, government doctors, both availing as well as non-availing NPA and engaged in private practice in their own hospital or in partnership are directed either to close down their private hospitals or to de-associate from such private partnership within 1 month from the date of issue of the said office memorandum. Comma, semicolon. The petitioners herein have invoked the jurisdiction of this court challenging the office memorandum dated 31/7/2023, whereby the Commissioner and Secretary to the Government of Nagaland, Health and Family Welfare Department have issued various instructions, thereby not permitting the in-service government doctors to engage in private practice, as well as also directing all private hospitals, clinics, nursing homes not to engage in-service government doctors, nurses, technicians, and health workers in their establishments. This court have duly taken note of that the said office memorandum dated 31/7/2023 have been issued in terms with Section 3, read with Section 8 of the Nagaland Healthcare Establishment Act 1997. And as such, the Mr. So-and-so, the learned expert, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the said office memorandum infringes the rights of the petitioners under Article 19(1)(g) of the Constitution of India. So, be that as it may, the learned counsel submits that the office memorandum dated 31/7/2023 have been issued in pursuance to the Nagaland Healthcare Establishment Act 1997. And as such, without a challenge to the said Act of 1997, the petitioners would not be in a position to succeed in the instant writ petition. He therefore submits that he may be permitted to withdraw the instant writ petition with liberty to file a fresh one by challenging the said Act of 1997 and as well as also seeking other consequential reliefs. Taking into account the above submission, this court is of the opinion that this court is of the opinion that without a challenge to the Act of 1997, the petitioners cannot succeed in the challenge to the office memorandum dated 31/7/2023. Under such circumstances, this court permits the petitioners to withdraw the instant writ petition and grants the liberty as sought for hearing about.
My lord, deeply obliged, Lord.
For admission, item number 16.
Please, Lordship. My lord, I'm mentioning on behalf of K. Angami. My lord, I'm informed that he is yet to receive instruction. So kindly allow 3 weeks time.
Okay, Mr. So-and-so appearing on behalf of
K. Angami.
the learned counsel appearing on behalf of the petitioner.
No, I'm for the state.
Appearing on behalf of the state, 6 for 4 weeks time for filing their reply. Taking into account the above, the instant petition stands adjourned to be listed on 5th of August 2024. The interim order passed earlier shall stand continued till the disposal of the petition.
Obligation.
For admission, item number 17.
Maybe Lordship.
Hmm.
Lordship, kindly grant me 1 week time to file my reply.
What is the matter about?
Lordship, it's about the taxation, Lordship, goods service taxation. The tax department has levied twice from the petitioner. Where I give by the original.
We are paying for the, yeah, CGST.
Lordship, CGST is outstation, so we have taken the consent from him that
We
we
are
will
paying
reply.
for the CGST, GST. Nobody.
No, one Lordship, one Charma, Mishra, one Mishra, AK Mishra.
Huh?
One AK Mishra.
Then
So since he's outstation now,
counsel appearing on behalf of Mr. Bonche. You have obtained the stay.
Lordship,
Why?
my apologies, Lordship.
Stay?
Stay, yes, Lordship.
How much is the demand?
Lordship, demand is a
15 crores, 61
Yes,
lakh,
Lordship.
35,722.
It's to Lordship.
Which thing? With revenue?
Lordship, we'll be filing our reply, Lordship. So let me come up for 1 week, Lordship.
Hello?
I'm for the petitioner.
Affidavit was filed on 18th of March. We are in the month of June.
Lordship, I'll be receiving the affidavit today. So I'll be filing on Monday. So it can come up after a week, Lordship.
The counsel appearing on behalf of the petitioner seeks an accommodation of a week for filing the reply.
Lordship.
That the matter be listed again on 21st of June 2024. The reply be filed by 19th of June 2024. The interim order postally stands extended till the next date.
I'll apply.
For admission, item number 18.
Lordship, I'd like to mention on behalf of Livika, Government Advocate.
Whom?
Mrs. Livika, Government Advocate. Instructions have been received, so we pray for 3 weeks' time to file our affidavit of opposition.
Non-payment.
Yes, Lordship.
You admit or don't you admit?
They have admitted,
Yes.
Lordship.
He-
Already admitted, Lordship.
Does he admit?
Yes, Lordship.
You've got your instructions?
Yes, Your
Hey,
Lordship.
where is it?
I'm on behalf of Livika, Your Lordship.
So
She's indisposed, so she can attend court.
you get the disposal in your name. Don't say that to dominate.
But she wants to file her opposition affidavit.
Do you admit or deny? That's all.
I'm not very.
If you
conversant
deny,
with the case, Your Lordship.
it's a different thing. If you admit, different thing. If you don't admit or deny also, the court will direct you to make the verification and pay. You can pay everything, whether he's entitled. That way that is. And you will be the main counsel. But hello. The counsel appearing on behalf of the petitioner respondent seeks for an accommodation of 3 weeks for filing the reply.
Opposition, Lordship, affidavit in opposition.
It's the matter, huh?
Affidavit in opposition.
File the affidavit.
Yes, Lord.
It's the matter again on 5th of July 2024. The reply be filed by 1st of July 2000. Affidavit in opposition be filed by 1st of July.
For admission, item number 19.
Lordship, in the last occasion, the counsel for the state respondents raised I was supposed to submit when?
For this one, 2007 notification,
Yes, so much.
21 to 30. This is grade 4.
Yes,
This is grade 4.
yes, so much.
Then grade 4 will be 18 to 35. To 35.
35.
And then any more?
No more
relaxation?
relaxation. This is for
Huh?
the ST. Lordship, in this respect, I would like to clarify para H of the
Huh?
office memorandum. Lordship may appreciate this office memorandum para I, which they are raising the issues, questions regarding the age of the petitioners. Now here, it is very clear, may I read, my lord? Here, the upper age limit of the applicant under this scheme means appointment, compassionate appointment may be relaxed in exceptional cases up to maximum of 5 years in addition to existing relaxation. So in existing to relaxation means I have an opportunity, another 5 years,
No, 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 no.
my lord.
Maximum is 5 years.
Maximum is 5 years.
So
Now, so
no.
my age become maybe 40.
You are 43.
No, but my lord may appreciate. In addition to existing relaxation.
Understood that
Yes.
existing relaxation cannot go beyond 5 years.
No, my lord, in addition to. The phrase here, addition to. My lord may kindly see. Here, 5 years in addition to existing. My lord may kindly see the para A. Here, maximum of 5 years in addition to existing. This is, my lord, compassionate appointment. So here is one, and the meaning is very clear. It's not ambiguous. So here, in addition to existing relaxation. So it can be another.
The upper age
Yes.
limit of the applicant under the scheme may be relaxed in exceptional up to a maximum of BI in addition to the existing relaxation, if any.
Yes.
So you mean to say that
So
the-
45.
45.
Yes.
Why?
So the upper limit of the age is 35 and relaxation is 5 years.
Where is the 5 years?
My lord, 5 years is there in that which they have.
No, 5 years will only arise is for serving government employees.
But my lord, this is compassionate appointment. The petitioner's husband is serving and he died on harness.
Understood.
Yes.
That person is dead. He's in heaven.
Yes, my lord.
How can you bring him?
But my lord, you see, and another thing is that, my lord, even another 2 years, because of the COVID, office memorandum was issued by the government of Nagaland. Their own.
Mr. Counsel, tell me one thing.
Yes.
When did you apply?
This year, my lord.
This year.
Yes.
When did your father die?
21.
21.
Yes.
You applied this year.
Yes.
21, what was your age?
My lord, 21, I was
41. 41?
40. Yes.
So if you were 41 on that day when your father died,
Yes.
COVID, no COVID, nothing, it doesn't have anything.
My lord, this is the wife of the.
There might be a delay which may be there, whatever, in filing, but your entitlement arose in the year 2021.
Yes, 20.
At that point of time, you were 41.
But my lord, here is the para 8 of the OM clearly states that maximum of 5 years in addition to existing. So the addition, not the phrase is there, existing relaxation, not the existing limit of age. My lord, may
In
kindly
addition to
proceed.
the existing, just for example.
Yes, my
you
lord.
Where in this language, why it is being used, just in most cases, the
And you see,
wording out there in the office memorandum in Nagaland seems to
Yes.
be different, maybe because of the population having more scheduled tribe out here. And as such, general seems to be an exception. In the same law, you find a general quota being given. And then the exception is to the SC, ST, OBC quotas, thereby giving 5 years, 3 years, whichever may be. However, while doing this, therefore, for general it is 30 years. You are general.
No. ST, 35, my lord.
Okay, so you will be 35. 35 plus another 5 years you have to be.
That is the relaxation.
40.
Yes, and
No.
addition to.
No. The in addition is only if you
My
are
lord,
the
this, it may not be applicable to all the appointment, but this is particularly in respect of the appointment
Yes,
and
Mr.
commission job,
Imsong,
my
what do you
lord.
say? What do you say? You are an additional government advocate general. Tell me. Can a person at the age of up till 45 apply? No, understood. He submits that in addition to that, another 5 years will be given. Understood, it's okay, 5 years. But 5 years will be from 35 plus 5, 40. Nothing more than that. So can it be given 5 years here, another 5 years there? Unless the office memorandum earlier said that 5 years will be given for in, additionally. If he was working out there, 5 years was given, that's a different spectrum. So what to do? Friday.
My lord, if I'm not mistaken,
Your Lordship, if I may, Friday you don't want to take a sad news back home?
my lord, if I'm not mistaken, the sentence, the meaning itself is very clear. In addition to existing relaxation, another 5 years. That is, relaxation is 5 years.
Where is that existing? Tell me.
No,
The
no.
existing is this.
The existing is 5 years.
From
my
where?
lord. That is,
Okay.
My lord.
We have spent so much of time. This is a case for this.
my lord, in that case, I may be allowed to withdraw and I may come in a different, I may approach in a different way.
Okay.
to
The
my
counsel appearing on behalf of the petitioner submits that he would not like to.
With the
further
liberty
press the
to
issue.
file afresh.
Huh?
With the liberty to file afresh.
Liberty for what?
My lord,
If
here,
if they come up with another relaxation,
no.
by the time you will be more
in- My lord, in this case, I may be honest with this honorable court. When these issues come up, I inquire about the petition stage, and now.
Okay, I'll
the-
do one thing.
The actual
Now,
age.
whatever may miss the council, I'll do it. I give you an opportunity till Monday. Don't take a sad news on Friday.
My lord, please.
On Monday, in the meantime, you just have a look out there on the basis of this office memorandum and find out if there is any other relaxation available. Okay?
No, there's no other notification, my lord, so far as this is concerned. So, my lord, if that is the case.
There's no
if-
liberty.
because-
This is not a case of liberty.
But my
I'm
lord,
very strict on liberty. Liberty, if you give like this, it will have far-reaching consequences. It's a case of bench hunting.
if that is the case, all the husbands should die before death. So, my lord, you see, para 8 is very clear. If we read in a different way, my lord. So I don't have any opportunity, then my sons and daughters are minor.
You see, that is why in a
Yes,
SAM,
my lord.
in a SAM, what they do, we also have a compassionate appointment.
Yes,
day.
my lord.
In a case, the age limit is not there. They've not put an age limit. You challenge this on the basis of that.
Yeah, particularly in memorandum, there is no age limit.
You
is
challenge it on the basis of
yes.
that because then you bring in the concept of there, which is the Supreme Court says. Wherein the Supreme Court says that age limit is not the question, it is the question as to whether a person, a family member would be able to survive, taking into account the bread earner had died. So the age limit cannot be put as a consideration. It's a solace. It is not a source of recruitment, but it is a solace. And as such, you challenge this office member. And there I can give you the limits. Okay?
My lord.
The learned counsel appearing on behalf of the petitioner submits upon perusal of the office memorandum dated 30/11/2007 that in view of clause 8,
Para 8, yes. My lord.
Clause 8 of the para 8 of the office memorandum dated 17/9/2015, the petitioner herein would not be entitled to be considered for compassionate appointment. The learned counsel further submits that the scheme of compassionate appointment is a scheme by which the government takes being a model employer, taking into account that the sole bread earner of the family had expired, grants an opportunity to a member of the family to be appointed to a post so that the family could not be put into distress pursuant to the death of the sole bread earner of the family. He therefore submits that clause para 8 of the office memorandum dated 17/9/2015 is in violation to the very concept of compassionate appointments. Therefore, he submits that he may be permitted to withdraw the instant petition, but with the liberty to challenge the office memorandum dated 17/9/2015. Taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner, however, is granted the liberty to file a fresh petition by challenging the office memorandum dated 17/9/2015, as well as seeking other consequential benefits.
Much obliged, my lord.
For admission, item number 20.
Yes, what is this? Non-payment?
Yes, Lordship.
You're
My
not
lord,
paying.
I have information that the department is constructed, otherwise
Really?
so it is allowed the
Yeah. How much?
3 weeks time.
Time granted to the petition, the Mr. Mohan Chand, the learned counsel appearing on behalf of the state respondent, seeks for an accommodation of 3 weeks for filing the reply affidavit in opposition. He submits that the department has already prepared the para-voice reply. Taking into account the above, this the matter again on 8th of July, 10th of July, 11th of July 2024. The affidavit will be filed by 8th of July.
My lord. Obliged.
For admission, item number 21. 7.
Yes, where's your reply?
This your worship. Reply to the order dated 7 June. I filed an affidavit on.
You filed a reply?
Affidavit, yes.
Where? You have a
Yesterday.
copy?
Yes, yes. It's already filed yesterday.
Has a reply come here? Anyway, that affidavit now, they just give me a copy of it. This page 10 document is the thing which covers everything as regards 4/3/2024. This paper notification.
It covers the whole thing. Including the summary revision of the.
And this notice for final publication was also widely circulated in the newspapers.
Yes, Lordship. One of the dating local dailies, Nagalambos.
Hello? Now tell me, you want to withdraw? I kept you for the entire day.
Your Lordship. In fact, Lordship, if the earlier matters were not disposed of, and regardless of whether it is published in a newspaper or not, I wanted to rely upon the section 35 also, because it can also be transported from the same constituency. If your name is there, it can be transported to the ULB also, Your Lordship, the provision is there. The same electoral roll of the same constituency, it can be used for the ULB elections also, Your Lordship. There is a provision on it. Yes,
That
Your
is
Lordship.
true. I've
Yes.
looked into that provision
My
also.
lord.
That can be very well done if the state election commission thinks that, no, we are not going for revision, we adopt this.
As far as the election matter is concerned, I know that Your Lordship was standing counsel for the Election Commission of India also, my lord. To that extent, I'm aware, my lord, but if my lord may kindly allow the withdrawal of this petition with liberty to file afresh so that I may try to find some other points also for the petitioner. This petition was also filed in a rush. And so there was barely any communication between the petitioner and the
See,
council.
you have the rules with you, na?
Yes, my lord.
You Today, as of today, nothing can happen with this case. Matter is gone. You cannot now do anything with 37. Now, what can you do is 13. You see, rule 13 or 11.
Lordship.
Rule 11 or 13.
One
There is a, what happens? Rule 9 stipulates about the after the final publication which has been made. Then rule 13, can you see rule 13?
My lord, yes.
Which now also permits you to enter. At a subsequent also you can do it.
Oh.
You see, you can subsequently do it in terms of rule 13. In spite of what has gone is gone, but then also you can enter.
My lord. Then my lord may kindly grant me this opportunity under rule 10.
Because I was, therefore you got that order late. I was just thinking what will happen to a person concerned if his name is not illegally. Yes, you have you have come late. That's a different thing which needs to also be taken care of.
My lord.
Because otherwise it will open another Pandora's box out there. Everybody will come. There won't be an end to it. Therefore, you have the similar provision also in the registration of electors 1961. You have a similar provision, almost a parameteria, form 2, form 3, everything. They have not, it is not that the state of Nagaland has come up with an ingenious idea of this. There's a copy from there.
Of course, it mostly borrowed your lordship.
So there also you had, but you see, there on that regard, one constitution bench has also said that the right to vote, which is there under section 62 of the Representation of People's Act 19, is not a fundamental right. It is just a right to vote. So that can be very well curtailed by the procedure. So this is how, if you don't apply, you can.
Lordship, the circumstance is a little peculiar, if not, my lord, given the fact that the petitioner is a resident of a particular area, has been a voter in the assembly constituency in the name included in the e-roll. Now, when the name is not included, your lordship, assuming that the name has to be removed.
Let's have an example. A person may very well have his name included in that constituency, but he doesn't stay there. My brother, my brother has his name out here in Gauhati. He stays in Delhi. Tomorrow, can he come up and say, look, and he is not there in the municipal. You see, therefore, for deletion also you need to move. Once you delete, then you get your name somewhere else.
Yes, your lordship. So when the petitioner's name, or for that matter, an elector's name is not in any other constituency and is in that particular area. Now, my lord, as far as election merits are
I'm not
concerned.
saying, just for example, a person, you must have seen nowadays, during this election, a lot of people have flown from America and all for the purpose of voting out here in India. They have their names out here. They are citizens. They are only OCI, overseas citizens of India. They still have it. They come over all the year out here to vote. May not be. They may not have in the municipal rules. They may not be there in the panchayat rules. May not be. Not necessary. Because there is a scope of revision which is mandated as per this. See, therefore, the rule categorically says, the act also says that either the state election commission may adopt the electoral
Yes.
rule or may carry out their own revision. So they have carried out their own revision.
Your lordship, whether the question of deletion of name will apply or not, because when a person is a resident of that particular area, having a property, also a proper house, is a continuous voter for years together, since the age.
Therefore, you can still do it under 13.
My lord.
Rule 13, you can still do it, but not for this election. This election is gone, but you can still do it. Because, therefore, if you see Rule 37, it's section 37, only stops this period from the date of filing of the nomination, final date till this. You cannot. Thereafter, you can again insert. You can very well apply for insert.
True, Your Lordship, but Your Lordship may kindly appreciate this fact, especially considering the plight of the petitioner whose case, if argued, is going to be in the present form, if argued, is going to be dismissed. So, Your Lordship, because a similar case has already been dismissed. So, my Lord, since this case is a covered case, it is my humble prayer that at least to look for an avenue to see whether there is any possibility for a petitioner to again come back on a different ground of any possibility on Monday or not, Lordship, for the satisfaction of my client and also for me to do a little more research work to assist this Honorable Court. My Lord, may kindly allow me to withdraw with liberty so that I may not file.
No, but the liberty has to be given with us. See, there's a difference between allowing to withdraw and allowing to withdraw with liberty. Liberty, if I have to give it, in fact, the judges, they don't do, but when you give a liberty, you have to give assign reasons. You don't give the liberty just for the sake. Therefore, you see all the liberty orders which I have given, all contains reasons why it is given. Because you say, to go for a CPC. This is a concept borrowed from the order 23, rule 1(3). It says that the liberty, if it is to be granted, you have to hear the other side and you have to then. Yeah, however, the council says out here, let me withdraw, and then slightly says that liberty. It's something which reminds me of that. Anyways, what to do? No liberty. What liberty? Give me a good ground. This is otherwise the case for dismissal. Properly done.
Your Lordship, at this point, there is no point arguing with Your Lordship after the decision is already pronounced in the earlier cases. My Lord, at least in appreciation of the section 37 clause 3, my Lord, at least liberty may be granted to me because as far as section 37 clause 3 is concerned of the act, my Lord, the language is not even stated as discretionary of the state respondents as such. Not,
that is what you are still urging.
No, my Lord,
liberty
that is,
for what? To go before another judge.
No, Your
Otherwise,
Lordship.
what? There cannot be any other liberty. Can there be a liberty out here when you are urging the same point?
Your Lordship may kindly allow me to withdraw with liberty. That's a request that I'm placing before Your Lordship again and again. But
Now, I'll allow you to withdraw. There's no quarrel with that. But how do I give you the liberty? Give me a good reason why. You have already raised 37(3). Give me a good ground. Like in the earlier case, I gave the liberty. I found out. Yes, somehow he can be allowed to challenge it by challenging the office memorandum. I told him. But give me one simple reason why, how. I'll give you
allow me to find out from my client on if she has any other genuine grounds also, Your Lordship. Because with a limited communication between the petitioner and the counsel, assuming that the matter would be covered by the other earlier 3 matters which are dismissed, this petition was.
Anyways, see, only liberties I can give you is if the petitioner is aggrieved by the inaction of that inclusion of his name in terms with upon application in terms with 11, the petitioner may still be allowed to approach.
My Lord.
That is the only way.
Your Lordship. I'll be grateful, Your
Get me
Lordship.
the municipal rules.
Like, copy of the rules was given to Your Lordship in the earlier
Yes,
case.
yes, it must be there inside.
No, it's okay, Your Lordship. I can.
No,
provide
I'll give it back to you. Please. Just. The petitioner herein have essayed the non-inclusion of her name, non-inclusion. her non-inclusion of her name in the electoral roll for the ULB election no, of the electoral roll for the in a hurry you have put here the why did you put here the Junib Boto?
My apologies, Your Lordship.
Non-inclusion of her name in the in respect to in the electoral roll pertaining to Dimapur so prepared by the Nagaland State Election Commission. Though her name duly appears in the Legislative Assembly constituency number 1, Dimapur, section number and name 1, United North Block. This code, by an order dated 3/6/2024, had directed the respondent number 3 to file an affidavit apprising as to whether the draft rules were published and if so, when. In addition to that, this court had also directed the respondent number 3 to apprise this court as to what steps have been taken pursuant to the representation submitted by the petitioner on 29/5/2024. In compliance to the order passed by this court, the respondent number 3 had filed an affidavit in opposition stating inter alia that the draft rules were published, stating inter alia that the notification dated 4/3/2024, wherein the various dates have been mentioned as regards the preparation of the electoral rolls, etc., have been duly circulated and the same have been also widely published in the newspapers, including the newspaper Nagaland Post dated 9th of March 2024. It has also been mentioned that the draft rules were also published in respect to ward number 1-23 of the Dimapur Municipal Council on 8/3/2024. This aspect of the matter was also published in the local daily Nagaland Post on 9/3/2024. It has also been mentioned that the petitioner's application dated 29/5/2024 was rejected by by holding that the time period for filing application for inclusion had lapsed. Taking into account the above, this court is of the opinion that the petitioner herein have been negligent. Hearing was not at all diligent and did not take appropriate steps in terms with Rule 7 of the Nagaland Municipal Rules, Nagaland Municipal Election Rules 2023. The learned counsel appearing on behalf of the petitioner submits that the petitioner, that from a perusal of the affidavit filed by the respondent would show that the petitioner had submitted an application for inclusion of her name on 29/5/2024. The respondent authorities, concerned respondent, could not have rejected the said application, in as much as the respondent may have a right not to include the name immediately, but the said application could not have been rejected in view of the mandate of Rule 12, 13, and 14 of the Nagaland Municipal Election Rules 2023. He further submits that pursuant to the results, isn't it, what's the word used in 37?
Your Lordship.
37, what is the last line mentioned? Shall not be during the period from final publication to.
May I read, Your Lordship?
Till. What does it say? 37(3), what does it say?
No amendment, transposition, or deletion of any entry shall be made under section 36, and no direction for the inclusion of a name in the electoral roll of a ward shall be given under this section after the last date of making nominations for an election in that ward and before the completion of that election.
Kept the said application pending till the disposal to be considered immediately after the final results are over. He therefore submits that he may be permitted to withdraw the instant writ petition and given the liberty to file challenging the said illegalities. Taking into account the above, this court is of the opinion that the petitioner, that a reading of clause rules 12, 13, and 14 of the Nagaland Municipal Rules, Election Rules 2023, permits the petitioner permits an elector to seek inclusion of his or her name at any point of time, irrespective of the mandate of Rule 7 of the said rules. Accordingly, this court therefore permits the petitioner to withdraw the instant writ petition and grants the liberty to refile, challenging the rejection of the petitioner's application in Form 3 on 30/5/2024.
To oblige your lordship.
And now, therefore, you can bring in.
My lord.
Otherwise, petitioner have the liberty under section 38, the bill. Otherwise,
No, no, no. That is not an appeal. See, section 37 gives you a very important aspect. You cannot insert somebody's name from the final date of nomination till this. Wait, it is another. Now, there is a revision being done normally. Normally, a revision is being done out there. And if a person wants to include his name, he has to do it as per the schedule, which is being prescribed in third prayer. And out of turn is being given if somebody's name is not there, which can be done anytime. You can today, like the Lok Sabha, you can very well, your name is not there, you can very well file it. You don't need to be only at that point of time. So his application, which is there on 29/5, which have been rejected, that rejection could not have been made. Maybe you may have considered it subsequently. Subsequent to this, now we are not doing it, subsequent to this.
Oblige your lordship.
For hearing, item numbers 22 to 24.
Yes.
May I please, Your Lordship, my lord, in the last order, state was directed to apprise the court that whether there is any office
Oh,
memorandum.
electricity.
Yes, so my lord, I'm informed that there is no office memorandum. In regard to
So-
payment of ex gratia. My lord, but Your Lordship will kindly see the last order in the.
No,
division.
I've seen
Here,
here. You see how, what do you do in terms of section 53 of the Electricity Act, 57? You have the Electricity Act.
my lord, liberty has been given to the petitioner to approach the authority whom for compensation or for payment of compensation under electricity. Your Lordship, will kindly see that read petition page number 56. Division page order.
Where?
Division page, page number 56.
53.
56.
Understand. Yes.
Para 20. The judgment. '69 day of 2020. Here, liberty has been given to the petitioner to approach the state.
Then what have you done? No, further in view of the so and so, during the course of the review, I have liberty to approach the state respondent. Her case is that she has approached and we have not paid. Isn't that, madam?
No, regarding the payment of compensation, they have not approached.
You're not approached?
After this.
Lordship, I was told that under the Electricity Act, my case is not covered. Lordship, if, Lordship, I would like to bring to your notice, of, this office memorandum. Lordship, it's in my additional affidavit in reply. Page 229. Lordship, it actually starts from 231, 231, page 231.
61?
231.
Oh, 231. Yes.
Lordship, this is an office memorandum from the
The
ministry.
result of attack by or during attack.
Ministry of Personnel. Lordship, this OM was circulated to all the chief secretaries. You will find the letter at page 230. And then it was notified in the state of Nagaland at page 229, Lordship. Lordship, the notification circulating this uh, office memorandum is at 229, Lordship. It was also published in the compendium of office memorandums published by the Governor of Nagaland, Lordship. And Lordship, we are asking for not extraordinary pension, ex gratia compensation at page 236, Lordship. 236.
Now, what is the definition of employees or government servants? These people come within the ambit of government servants. That is the main question.
Lordship.
How do you bring yourself within the ambit of the government? Yes, all these things will be entitled. But first, don't you have to be a government servant? You prepare
Lordship, in that
properly.
case,
You prepare properly.
Lordship, my senior will lead me, not
Huh?
not me, Lordship, my senior will be leading me in this
Your
case.
senior will do it.
But yes, Lordship, however, we want clarification on whether this annexure 137(1) is applicable to the state of Nagaland, Lordship. And so,
When do you want it?
My lord,
According to
here
the-
I'm yet to file rejoinder affidavit to the affidavit in reply filed by the state, by the petitioner. So kindly allow me 1 week. Yes, lord.
And did you approach the authorities
regarding the compensation for ex gratia,
as regards
no,
electricity?
no, Lordship, we have
Why?
not. Lordship, we want ex gratia according to this office memorandum. Lordship.
But then also you are asking, you are making a prayer out there that you are entitled to as per the Electricity Act. Why you are asking them?
Lordship, that is
You
not
are
a,
constricting yourself to the office memorandum. See your prayer in the petition.
Lordship, our prayer is, yes, according to the writ appeals
You are
judgment
asking,
and order, Lordship.
but you have not approached. You want this court to issue a mandamus. And a mandamus be issued without demanding it.
Lordship, we have already approached this court. This is the, initially by filing a writ petition and then a review petition and then the writ appeal. And now this is the court litigation and Lordship, the petitions are,
Okay, we give you
Yes.
time. When do you want it?
1 week, my lord.
1 week.
Yes.
Let the council appearing on behalf of the respondent. 864. 1 week time for filing a reply to the additional affidavit filed by the petitioner. Council appearing on behalf of the petitioner also submits that her senior would like to first, that the senior would like to further address this court. Taking into account the above, list the matter again on 27th of June 2024. The reply, if any, be filed by 24th of June.
obliged.
Much obliged.
For hearing, item number 25.
Please, Your Lordship.
Yes.
Please, Your Lordship. Lordship, the principal counsel is indisposed, is undergoing medical treatment.
Who?
The principal counsel is undergoing medical treatment at the moment.
Oh.
Kindly,
You want an adjournment?
Lordship.
Council appearing on behalf of the petitioner seeks for an accommodation. Taking into account the above, the matter stands. What is this appointment of dealership?
This is a dealership.
Then what happened?
No, he was awarded through lottery. Then while submitting documents, the documents got lost, which was earlier submitted. the originals.
Which lots?
It's a draw clause.
Huh?
It's a draw clause.
Huh.
He got selected, not a selection procedure, but he got selected and he submitted. The procedure is that you submit the documents in advance. Thereafter, if you get to the draw clause, they are evaluated. The photocopy is like. After the draw clause was taken, he was asked to produce the originals. He said that he sent a letter to the IOCL, the office, saying that I have lost these. Here are the set of documents, an advocate's letter, a separate advocate's letter certifying his land, which was obviously submitted after the last date of application. Did not tell you if the photocopy is already submitted. And that was also intimated to the IOCL after they had cancelled his candidature. It was not technically a cancellation of candidature. There are three categories, group 1, group 2, group 3. He has been demoted basically from group 1 to group 3. Group 1 C. Group C. First group is those who have farm land.
Who have the firm?
Yes.
B is who have lease offer.
Offer.
And C is who will get with other general.
Yeah.
So he wants to be in group 1. Where the draw of lots will happen. And then
I know that he was
are you still interested with the project?
Yes, because we are trying to go ahead with the draw. Plus, there are other candidates as well.
Understood. But are you still interested taking into account 5 years have passed?
Well, we need that because we need the plot. But the problem is that he has not made party the other candidates who are there in the draw clause. And they have also not come forward to express their.
Anyway, draw of lots, you don't need to make other parties. But whether he has rightly been done from A to C, that's the only question.
That is the only.
There's nothing more than
there is nothing.
Let us see what is this case. Yes, tell me, what is your case?
Yes.
It's a simple matter. These type of matters are disposed of many. You need to even look into.
Yes, after getting through the draw of lots.
See, show me the comments like their letter. Why they have made you group C. Group 2. Where is that government's letter? IOCL's letter? Huh?
Annexure H.
Annexure H, page
33.
Application for Iman of so and so from Nagaland Gate. Is referred to. Okay, now what are the documents you submitted?
Lordship, in the earlier listing, a different advocate had given a clearance for the land.
To me, well, what are the documents you submitted?
Six. 40, start from 43.
In the earlier, it is this one, page 29, annexure G was submitted.
No, this is subsequent.
The subsequent one is page 43. First one is.
Okay, whose land it was?
No, his land, the petitioner's land.
Then?
But because of the documents that was lost, which was submitted before the draw of lots,
was
different from the documents that was submitted after draw of lots. The advocate documents certifying the land, because he had lost the one that was submitted earlier before the draw of lots. So he had got the document from another advocate certifying the land, and he had submitted, which was treated as.
No, you had a last date of submission of documents, isn't it?
That was not accepted. by the office, saying that you have to submit the documents that was submitted earlier.
Understood. You had a last date of submission? Did you submit the documents before the last date of submission or not?
Lordship, the office refused to accept, stating that the documents are not with the
His last date of submission is 25 December 2018. He has to give.
When?
25 December 2018.
25/12/2018. Okay, then?
Before that, he has submitted the photocopies and the annexure is relevant annexure is at page 46, where he has submitted page 46.
This document?
This document, 22nd December 2018 by 1 K. Lotha.
That I have perused the documents pertaining to the land at so-and-so, situated at so-and-so, by so-and-so, who have applied for so-and-so. Then what happened? Thereafter?
Thereafter,
This is the only document he has given.
No, my lord, this is the document in bone of contention, basically, in the ground. There are others, they are not in dispute at the moment. Then my lord may come back to page 20, after his loss, page 29.
Page 20?
29.
Yes.
He gives another affidavit, which is as part of his declaration. My lord may note the date below. Below at the bottom right hand corner, 7/2/2019. The date, his submission, 7/2/2019.
So this is later?
This is later. And page 32. Another advocate gives a certificate.
This is after?
After.
These have no value. This can be taken.
He cannot accept that.
Then that's it.
That is the word we rejected it. We said that since we cannot accept your land documents, therefore your candidature is downgraded. It is deemed that you have no submitted any land documents at all. So from category C, A to C. Thereafter, he says that he has lost it. But if he has lost it, then he has to submit the original advocate documents. Person who gave it at the beginning, the original advocate, Mr. Lothar. That person has to come forward and sign an affidavit stating that yes, he looked at the land, he certified the land.
Both these letters, except the date. Oh, it's the same one. Where is his forwarding 23? There's a forwarding also, just now you showed me, no? Which one?
Page 29 was the affidavit cum declaration.
Okay, there is another one. So this is of 7/2.
7/2.
This is what land?
This is the same land, but because he has lost, he said that I have lost the affidavit cum declaration as well as the advocate's letter, originals, along with other documents. So I am submitting any afresh because originals are required. So instead of submitting afresh from the same person who was certified before the last date of submission, he goes and finds another advocate.
The different advocate?
Yes, different advocate. Page 32, Sudipta Acharya. Page 32.
Okay.
Sudipta Acharya, not Kilota. This is for all intents and purposes a new document. We do not have this document as on the last date of submission of the application.
So your case is that pursuant to that he duly submitted his documents in photocopies. Later on, when you ask for the originals, he submitted other set of documents from a different advocate in a different undertaking or affidavit. It's not the earlier one. And as such, you downgraded him from group 1. That's it.
Yes.
Okay.
Lordship, the case is, we appreciate the fact. It was that since the time was for submission of documents was running out, he was directed to get documents and he was directed to submit.
Mr. Counsel, tell me one thing. How many persons participated in that who are in group 1? How many are there? You have finalized, now how many are there in group 1?
where there are around 5. There is no averment as such.
Huh? Yes.
There is no averment.
Paragraph 2, page 2, what is this?
Affidavit in opposition, there is no averment.
The
Here,
details
there
whereof
is
are
5
followed.
interested candidates.
Huh?
5 interested candidates, page 2.
Yeah, that is it.
Yes.
There were only 5
Five.
there,
Five.
of which the petitioner is Sisiva.
Sichaga,
He is in group 3.
group 3.
Now, others are in group 2. So the moment we accept his petition, the chances of the other persons goes below.
Now they are on a priority basis, their applications are on priority being group 1, 3. 1 is at par with him group 3. The 3 are above him as on date. So if any relief has to be given, granted to him, they have to be. That is the proposal. And this was
So
given in.
earlier it will be a chance of 33%, now it will be 25.
And in fact, that Honorable Court also asked them to impede several occasions.
They're not.
They're not.
So, Mr. Enough. Then, now, this is a case of cost. What do you say, Mr. Counsel? Cost. Cost upon him. He has spended a petroleum for a long time. This is where?
Judicial.
Dimapur, Manja, yeah, Manja, near Nagaland Gate. Dimapur.
The important place.
St. John. St. John.
You see, the question is, the problem is this. The rules categorically mention that you have to give that particular set of documents and originals are to be produced. When you were asked to produce the original, you didn't have the original, so you give another set of the same documents in original, which they did not accept. Whether it is mandatory or directive to give the same or not, that means you actually did not submit. You want that those documents should not be at all taken into consideration. The earlier set. If the earlier set is not to be taken into consideration, the next question is, did you apply at all with any documents? And if you have not applied at all with documents, you are therefore to be brought within grade 3. Because group 1 are those who offer land. Group 2 are those who has an offer. What is that?
An offer in hand.
Offer in
Those
hand
who
to
have
get a land.
owned and lease in place, and those who are proposed.
And the third is who has nothing. So you therefore come on the 3. Now the question is, therefore I asked you whether the department is interested. If the department is not interested, they can very well go ahead with another fresh tender you can, which is not, they are still interested. Now, if they are still interested, the only recourse left is what? You ought to have challenged this, and other person is affected. And we have not completed them. So, 2019 matter finishes.
Let the principal counsel.
Huh?
Let the principal counsel take up the matter.
Who is the principal?
Mr. Lucam, please dispose.
Mr. Lucam. Hello? We have it on next Tuesday.
What should be undergoing treatment at the
Huh?
moment? He's undergoing treatment.
Treatment? What treatment?
For Tico and for Tico.
Huh?
I'm not very sure, but. for
Then
Tico-
you engage somebody else. The petitioner has to engage somebody else. You can't have it for a long time.
No,
Is
Lordship,
that
let it come
a
out
stay?
2 weeks. after
No, I've heard so much time has been given. What is that 2 weeks? Ask your client to engage somebody else. We have it on Thursday. That has to want to make some additional better arguments, make better arguments, engage somebody else if you are not in a position. That is what I can. But you see, the question is, or we make it the state. You can't take that. You make it the state.
Let it be decided on the.
No,
after 2 weeks.
it is apparent. There's nothing of it. See, at one point of time, there was the question of directory, mandatory, Buddha steel, and all this aspect. Now there is nothing. It is absolutely good. They are the drafters of the year. They know what is directory, what is mandatory, and it is for them. And the court should not second guess. Yes, any other date you want? When?
Sure, after 2 weeks.
No, that is not possible. You have already spoiled so much of that. The matter upon be heard at length. The learned counsel appearing on behalf of the petitioner seeks some bits that he may be the senior be given an accommodation today for advancing further arguments in the matter. On the other hand, the learned counsel appearing on behalf of the IOCL submits that there is a stay order operating since 2019 and the respondent authorities are respondent corporation is suffering a lot. Considering the above, this court fixes the matter, having heard the matter at length, fixes the matter again on 13th of June 2024.
Lordship,
So the matter is shown as part of this. Yes, on 13th goes. Oh, what is that? Is that it's a 10 minutes dictation matter.
For hearing, item number 26.
Yes. What is this?
This is a seniority dispute, seniority dispute in the ring of forest rangers.
yeah, the petitioner, he was appointed from the waiting list.
From the waiting list?
Yes, and he is now claiming seniority over the person who were originally selected.
Lordship is having selected.
Yes,
Lordship in the year
he
2011.
failed in the NPSC exam.
No, not here. Lordship is having like this.
Yes,
In the year 2011, 4 candidates were recommended by the Nagaland Public Service Commission. Lordship, out of the 4 candidates, Lordship, 1 candidate was recommended from the general category.
Okay, Mr. Liverpool, we'll do one thing. We'll call it a day today. Call it a day today, enough.
Lordship, we can have next week. Next week.
Hello, when do you want it?
Your Lordship, let's make it on Friday, because Lordship want to stay.
This Friday.
Next Friday, for me to take would be difficult because you say, I wouldn't be for me to take, but anybody else takes it. Because Friday would be,
No,
on Friday, we normally, we are going the next day, no, or that day.
otherwise this is a short matter.
My learner senior friend, maybe she's not conversing with us. It's a lengthy matter. But it's a matter.
No, because it's appointed from the waiting list.
And
And we joined
Lordship,
this
the
service
Indian
after-
seniority list, this was issued based on the judgment in order passed by the division bench. The judgment passed by the division bench that is not applicable in the present case, since I was not a party in the writ proceedings. And as well as the ratio laid out in the judgment passed by the division bench is a issue between the direct recruit and the promotees. However, the issue involved in the present case is a seniority dispute between the direct recruit of the same selection. So the issue is totally different. The basis of the.
When do you want to tell me?
Tuesday, next Tuesday.
Lordship, I won't be available.
So next week not available?
On Friday.
You are not there on Monday, Wednesday,
Yes, on Tuesday I will leave you. So,
Tuesday.
yes, yes.
Let it come up. Is there any stay?
No, Lordship, no.
Let
There
it come up.
was a stay with the consent of the parties who vacated the stay. Since there was subsequent promotional post, the petitioner as well as the private respondent are now during the pendency of writ petition, they have been promoted to the higher post. Next promotional post.
Can we have it on 20th of June 20, Thursday? Hmm? I am not there. But anyway, you see, I can take it up on Monday if you want. She is going on Tuesday, Wednesday, Thursday. She's coming.
Your Lordship, in that case, after 2 weeks.
Eh?
If my learner friend she will out of station after 2 weeks.
Should we fix a date? No. 18.
No.
20 would be better.
24. 24. On 25th.
24?
So many benefits, it will be clear, so.
Okay. Whatever.
25th, Lordship.
Eh?
25th.
20?
25th.
25th. Okay. The joint, the matter is and adjourned to be listed again on 25/6/2024. Okay.
So great, sir.
Yes, sir.